petitioner, matter stands adjourned to enable her to obtain instructions. List after
2 weeks.
2 weeks.
I pray the motion.
Yes,
I pray for listing the matter as service all completed. Any
okay, give to the court master, they will have to adjust. Here for listing, give it to the court master.
May I please? May I
Yes,
please? My lord, regarding item number 17 and 18, my lord, both the petitioner is same, my lord. We have challenged the suspension order, my lord, but in the meantime, we have been promoted suspension. But only thing is, my lord, area salary for it is not paying, but then promoted to the next level to the post of professor. In Assam.
then well, that may not be a part of the prayer.
Yes,
So that you'll have to make a request to the authorities.
and they will get notification for rules.
An observation, my lord, liberty.
Item,
17 and 18, my lord. I've given the copy of the order.
item 17. 18. Mr. B. Purkar and counsel for the petitioner, upon instructions, has submitted that during the pendency of this petition, the petitioner has been promoted. He submits that the petitioner has a claim for some part of area salary. Mr. S.C. Kyal, standing also for the Assam University is present. Next para. As the petitioner has been promoted, or the matter appears to have become infructuous. And accordingly, the matter stands closed. Mr. Howard, it is provided if the petitioner has any claim towards some monetary benefit from her, the petitioner would be at liberty to move the authorities. Okay. Yes.
May I please, your lordship, item number 11 has become infructuous, lordship.
11.
11.
Okay. Upon instructions, Mr.
D. Deca.
D. Deca, General Counsel for the petitioner, submits that the matter has become infructuous. Accordingly, the matter stands closed. All the respondents are represented.
Obliged, lordship.
Yes.
I beg to mention item number 7, my lord. In this case, my lord, I am told today, my lord, I will file an affidavit in reply, my lord. May be taken up, my lord, in the next week, my lord. Today, my lord, I will.
Okay. Mr. Sharma, then counsel for the petitioner, submits that you will be filing affidavit in reply in course of day today. Accordingly, is this matter after 2 weeks.
Obliged.
My please, your lordship. Firstly, I have to mention for item number 40, it's a complaint letter.
40.
Yes. Complaint letter. The order has been complied with. There before you kindly close the letter.
Both sides are represented. Miss
Z. Deca.
J. Deca, counsel for the petitioner, upon instructions, has submitted that the order of the court has been complied with. Therefore, on satisfaction, this contempt petition stands closed.
Okay.
Yes, lordship. Lordship, I beg to mention item number 6, my lord. I am appearing on behalf of Ms. Sasbora. She met with an accident, my lord. So matter may be taken after 3 weeks, my lord.
Okay. Both sides are represented. It is submitted that Ms. Asbora, counsel for the petitioner, has suffered an accident. Accordingly, matter stands adjourned today, list after 2 weeks.
My lord.
Detailed, lordship.
I need to mention listing a content matter, my lord, regarding in advance. Because
Give to the court master, they will have to make some adjustments.
Lordship, I beg to mention item number 37, lordship. The order is already complied, lordship, and the court closed the matter. 37.
Okay. Upon instructions, Ms. J. Chetri, Learned counsel for the petitioner submits that the order of the court has been complied with. According to this, matter stands closed on satisfaction. Yes,
May I please, Lordship? I have to mention item number 10, Lordship.
10.
Yes, Lordship. London Angus Council, Mr. M. Khan, who is acting in ICU of Medical Hospital, Lordship. Is the matter taken up?
okay, both sides are represented. It is submitted that Mr. M. Khan, learned counsel holding the brief, is indisposed. Matter stands adjourned today, this after 2 weeks.
With the
Yes.
permission of the other side, I have to mention item number 13. A senior region in league, Lordship.
15,
13, 1 6.
13. Okay,
The 2 week, Lordship.
upon with consent of the other side, then counsel for the petitioner pays for adjournment. Pair is allowed, list after
2 weeks, Lordship.
2 weeks.
May I please, your Lordship, I beg to mention item number 30. It's a contempt matter, Lordship. Lordship, in this matter, all the respondents are retired. Therefore, Lordship may allow us to file IA for impeachment of the present incumbents, Lordship.
Okay. Upon instructions, the learned counsel for the petitioner submits that the respondents have superannuated during the pendency of this contempt petition. And therefore, we place for some time to file an appropriate application for impeding the necessary incumbents. The concerned incumbents, after putting them to notice, to comply with the order of the court. So matter stands adjourned today. List along with the impeding application as and when filed.
May it please, your Lordship.
Yes.
I get to mention on behalf of P. Mahanta, my lord, item number 4, my lord. Maybe adjourn for 2 weeks, my lord. Taken consent on the other side, my lord.
Okay. Consent of the other side. When counsel for the petitioner pays for adjournment, there is allowed, list after 2 weeks.
Next.
Lordship, I beg to mention for listing of an admission matter next week, Lordship, on 15th. The matter was last listed on January.
Give it to the court master, he may have to make some adjustments.
May it please, your Lordship, my lord. Item 25, my lord. Of course, the orders matter. But here in this case, my lord, I have my instruction, the matter is under process. Regarding payment of the area salary in the directory. So may I pray that for a longer time, the matter may be kept. Evidence. It will come
Okay.
after.
Both sides are represented. On the prayer made by Mr. M.S. Rasburiya, the learned counsel for the petitioner. Matter stands adjourned as the petitioner expects some development in the matter. List after 4 weeks.
A bit longer time, my lord, because it will take under process, it will be taking 1.5 months.
Okay, list after 2 months. Yes,
May I please, your Lordship? My lord, I beg to mention for listing of an admission item, my lord.
give it to the court master, he'll have to make some adjustment.
Fine.
Or prayer for listing, give it to the court master.
Fine.
Please, your Lordship. My lord, I pray for listing this matter for withdrawal. May I pray, your Lordship, item number 21, bail hearing method. May I pray that the matter will be taken after the motion matters.
My lord, actually, my lord, today, my lord, by mistake, my lord, CD is not been given to us, my lord. It's available in the office, my lord. So I have not also gone through, my lord, after some or usual time, my lord, when the item reached, my lord, because I have not gone through, my lord.
2 o'clock then,
My lord,
you can do his other work and come back.
I have some other.
on serially, my lord,
In usual way. Then after the admission, they in usual.
Okay,
So I recommend item number 4, your Lordship. Senior region leave, your Lordship.
or somebody has made a mention. Okay,
daily list item number 1, motion BA.
Some university.
That is your lordship.
Yes,
Lordship 439 application lordship. This is second bail application lordship. Earlier lordship was
we were arrested when?
arrested on lordship 27/6/2022 lordship and as on
27/6.
today lordship. As on today lordship 316 days lordship. That is lordship 10 months, 12 days lordship.
Where is the previous order?
Page 74, my lord.
Order lordship page 74 lordship.
We're listing it on Friday along with this application.
Earlier, my lord. Earlier, my lord. But that is, my lord, rejected on, my lord, January, my lord. Last, my lord, 4 months, what progress, my lord, in the, my lord. Maybe, my lord, up to the status of the LCR, my lord.
The charge sheet is submitted in this case.
Lordship charges submitted, charge already paid lordship.
Okay, what is the stage of the trial?
Lordship, at this stage, now the case is fixed for lordship appearance lordship.
For appearance?
Lordship. And in this case, lordship, other 3 accused persons already released, discharged, already discharged lordship. I have stated in paragraph 7 lordship. Other charge sheeted accused lordship, the 3 persons lordship. They are already lordship discharged from the alleged offence lordship. At this stage, lordship, record may be called for lordship.
Where you have made a statement that there others have been discharged, where are they? Where is that statement?
Lordship, I have stated in lordship, para lordship. Lordship, para 5 lordship,
Page.
page 5 lordship. Lordship, kindly peruse the order dated 1/12/2022 lordship.
Page.
Lordship, that is page lordship 52 lordship.
Okay, so we have everything, we'll get it listed on Monday.
On the, my lord.
53 lordship, 11 page.
On 15th.
Just. Where is the previous order you said?
Page 74, my lord.
74. List on 15/5/2023, along with the records of BA 2503 of 2022, where scanned copy of the case records are available. Okay.
Okay.
Think, my lord, once the matter was mentioned before this court and new matter, your lordship said that you have to make an appeal with the Honorable Chief Justice. Accordingly, application was placed and it is been listed before this honorable court. Now, my lord, I will tell one thing. In this case, my lord, 25/1/2022 it was filed. And it was, there were a lot of defects. Client also didn't, my lord, contact my lord. And ultimately it become wiser and they contacted and they want to pursue this case. And the defects were removed, my lord. So on the basis of my complaint, my lord, that another case was filed before this honorable court. Page 92 is my complaint
So just one.
to the returning officer.
The election results were declared when?
The results were May 2021, my lord.
What your lordship can note down 5/3/2021, the notification issued regarding election in state of Assam. Page 43.
No, from the date of result, the limitation will be counted.
Yes, 45 days. 45 days.
Yes. So this results were declared on May 21.
Yes, May 21.
The filing is made on 25 January 2022.
I'm sorry, my 25 January, yes.
Yes. So how do you explain the limitation?
I am taking the judgment of the Supreme Court, my lord. COVID, my lord. At page 140, my lord. 140. At page 143. 143. Twenty-seven, 2021.
Okay, so I'm issuing a notice then,
Yes, only notice, my.
but I'll keep the issue of maintainability open. Let
Yes,
them
yes, yes. Sure, my.
make their submissions on that.
Yes, yes. Why not?
But Mr. D. Das, that is senior counsel, assisted by Mr. A. Talukdar, legal counsel for the petitioner. This election petition has been filed to challenge the election of the respondent to the Assam Legislative Assembly from number 8, Algapur Legislative Assembly constituency, Hailakandi, in respect of the elections for which results were declared on
2/5/2021.
2/5/2021. Next, the learned senior counsel for the petitioner has submitted that to explain the delay in approaching the court. The petitioner is taking is placing reliance on the order dated 27/4/2021.
There is another order which is passed subsequently. I think that's not been annexed. That's what I am sure, I recollect. This somewhere in the March, some 2022.
Okay,
This is, I don't know, my lord, this.
Okay. 21, and or any other or the past thereafter in connection with miscellaneous application number 665 of 2021 in SMW within bracket capital C bracket close 3 of 2020. Give a dash, then in RE cognizance for extension of limitation comma which was passed by the Supreme Court of India. Next paragraph. Accordingly, keeping the issue of limitation open, issue summons to the respondent Next paragraph. It has been submitted that the service copy of the election petition has already also been filed.
Yeah.
So accordingly, notice may be issued, making it returnable on after 5 weeks, give a date.
23/6.
23/6 for service report and filing of written statement by the respondent.
Lordship has fixed which deadline? After 5 weeks.
Date
23/6.
23/6.
20.
23/6.
Okay. I think we have to annex one more judgment of the Supreme Court after the judgment.
Bring it on
But
record
that
by
will be on
David.
record.
Just a moment, I will see that.
Number 3.
Yes,
My lord, first of all, for the time being, my senior is on like, my lord.
this interlocutory application has been filed for implementing the opposite parties. Number 4 and 5 as respondent number 4 and 5 in the conducted contempt petition by putting them to notice dated 9/2/2023 to comply with the order of the court. Next, this application stands allowed. In the contempt petition, you write, in view of the order passed today in IS Civil 1121 of 2023, the registry shall implement the opposite parties number 4 and 5 in the said interlocutory application as respondent numbers 4 and 5 in this criminal petition, contempt petition. Next paragraph, petition shall take steps within 2 days for service of notice on the newly implemented respondent numbers 4 and 5. So notice is made returnable on so and so. List accordingly.
21/6. Item number 5 for admission.
May please, your lordship.
Yes,
Lordship. It's a case of process regulation of service petitioner, as well as lordship to release the area salary since 2006. Because the petitioner was initially appointed in the year 1991 on the leave vacancy of one Vinod Chandra Das, a grateful employee. Subsequent to that, lordship, his service was lordship extended for another 2 months by the inspector of school Mulberry, and thereafter lordship may come to page 16. Annexure C. The type copy lordship, original is the next page 17.
Yes,
Lordship. So Lordship, by this order, Lordship, his service was extended, Lordship, for up to Lordship 31st of May 1991. In the same vacancy of leave vacancy of Sri BC Boysa as grateful employee. Thereafter, Lordship, on being satisfied, Lordship, in the performance of this petitioner, he was Lordship allowed to continue his service.
but Mr. Kalita,
Lordship.
post Umadevi, how can we allow this prayer?
Yes, Lordship is absolutely right. Lordship, thing is that Lordship school was provincialized long back in 1977. So Lordship, only thing is that Lordship, thereafter Lordship, this petitioner was an appointment letter was issued by the managing committee. And on the basis of this appointment letter, Lordship, all the process was initiated, Lordship, by the inspector of school, as well as Lordship, it was also informed to the director of secondary education. Subsequently, Lordship, in the year 2005, and by the inspector of school, this petitioner was allowed to draw his salary, Lordship, which is 2002. So now the question is, Lordship, from my limited knowledge, Lordship, since Lordship, his service was, though it was not regularized, Lordship, but he was allowed to draw his salary, regular salary, since 2000, which effect from 2022 or 2002. So Lordship, thereafter he was working Lordship on regular basis without any break, Lordship, but immediately in December 2005, his Lordship, his payment was stopped.
From when? From when?
From December 2005. And it was Lordship, the order of payment. Lordship may come to page 25. Page 25, the type copy, Lordship may read the order, Lordship.
Mr. Kalita, the problem is that once man is not in the list of employees for the government,
Lordship.
because now with the advancement of technology, they are able to track that these people, some people who are not duly appointed
Yes,
were withdrawing, and therefore these were stopped. The problem is that
Lordship.
unless the appointments can be shown,
Lordship, what I have understand, Lordship, since Lordship, this release order was issued in the year 2005, probably Lordship, there was a relaxation provision in the rules of 1982 as well as 2003 also. Rule 15 of 1982 rules and rules 29, which is corresponding to 1982 rules, provides Lordship some relaxation may be there, Lordship. Lordship may kindly have rules 1982. Secondary education provincial services 1982.
page,
It is page, Lordship, page starting from page 586. The relevant is 599,
yes,
599, Lordship.
599.
Lordship. 599, rule 15.
Oh, what is the name of the rule?
Assam Secondary Education Provincial Service Rules 1982.
Just wait. Assam Secondary Education Provisional Service Rules,
1982,
82.
Lordship.
No, but is it not 2003?
2003 also, this provision is Lordship corresponding to 2003 also. 2003,
Oh.
Lordship, Rule 29. That may come to 183 of 2002 3 rules. Page 183.
But because you see this 29,
Lordship.
there can't be a deeming provision. There has to be an order of the authority
Lordship.
saying that the rules have been relaxed.
Yes. Lordship, also Lordship, they have filed their affidavit in opposition, Lordship, but regarding this point, Lordship, this their affidavit is also silent, Lordship. How, Lordship, this petitioner is allowed to draw his salary?
Mr. Gogoi and Mr. Sharma,
Yes, madam.
in the affidavit filed by respondent number 3, there's almost an admission. You don't take a plea that since he was not regularly appointed, he will not get it. You say that you have written to the government. If that is the sense, why should we not direct? Because you did not deny it.
My lord, he was appointed by the managing authority And my lord, he was not go by the selection procedure, my lord.
Where is your stand that?
Yeah,
Read
my
the
lord.
stand. You can't be permitted to make that argument.
Here, my lord. Affidavit filed by the
Respondent number 3, I see
respondent
that.
number 2, my lord. Respondent number 2 also filed the affidavit.
Where is that?
Here, point number 5. That the petitioner was not working.
Just a moment.
Yes.
Just a moment. Who is number 3? Who is respondent 3?
Respondent number
Inspector of
2.
schools.
Inspector.
Yes, my lord. Director.
Yeah.
Affidavit filed by the director.
Now, how do you reconcile that? Respondent number 3 files an affidavit.
Yes,
He doesn't take a stand. He is the inspector of schools.
yes,
He doesn't take the stand. The director takes a stand.
yes.
Now, there are
Director.
two conflicting statement by two authorities
Yes.
of the same department.
But my lord, there is in the statement also it is stated that at that time there was no provision in the service bill in force to appoint or engage any person on honorary basis by the managing committee in a provincialized secondary school. In this regard, my lord, one citation also we have provided here, my lord. Dambodar Kolita versus State of Assam. Please. And my lord, our division bench also, it is available, my lord, in Jahangir Alam versus State of Assam. And moreover, another judgment is Abdul Bari, my lord.
But Mr. Sharma,
Yes, ma'am.
this, the rule which is previous to Assam Secondary Education Provincial Service Rules, 2003, is which rule? What rule was prevailing before this 2003 rules?
It is 1980.
82. Which page in this book?
My lord, 790, my lord.
790.
Yes, ma'am.
But then, Mr. Gogoi, we can't save your case. If, because there must be something else. This can't be, 82 cannot be.
My lord,
Otherwise, my lord, legally, we see the, my lord, right of the petition.
No, Mr. Gogoi, I have a reason to ask that. You see, if you go through this Assam Secondary Education Provisional Service Rules 82, which is now being shown before us. You see, the cadre means the cadre shown in Rule 3. It does not contain
Using the 82 rules.
82 rules.
Right.
So grade 4, this Chowkidar is not included here. It is only teachers in
Lord.
Schedule 1. So therefore, I understand that it should be 1977 rules. This is only for teachers. That's Schedule 1.
Yes. limited to
Correct.
teachers. Right.
So is there can't be a Chowkidar. So you come to this 77 rules. That is at which page? 77 rules.
My lord. Yes.
352, right?
Yes, my lord, right.
352. Three 52 says all employees to be government servants. Correct.
Yes, ma'am.
And now this says this has something with appointment. Now, here you come to this provision of definition provision 2,
My lord.
12. School authority means the director or inspector whose approval is necessary for appointment or regularization of the appointment of an employee in a secondary school.
Right.
Correct.
My lord.
Now, this inspector is covered here. So if the inspector permits him to draw a salary, will it not be a deemed what do you call? Approval.
My lord, thereafter, our honorable High Court has delivered the judgment of Jahangir Alam, my lord, and Abdul Bari, my lord.
Lord, so you will see my lord definition of employee. Employee means a person in the employment of a school working against a regular sanctioned post and whose appointment has been approved by the school authority wherever such approval was necessary. Existing employee means an employee who is on the appointed day in the regular payroll, employee against regular sanction, and whose appointment has been approved by the school authority. Now, the appointing date is that
It was not leave vacancy, it was,
Lord, you will see, my lord, that's why, my lord, page 20, the appointment is of, my lord, honorary basis. That too against a non-existing post, not a non-sanctioned post, but non-existing post. There was no post at all, and this appointment was made by the in-charge principal of the particular school in 1992,
page 20.
page 20. Now, Lord, you will
Yes,
see the authority, it cannot be an appointment, he was engaged, actually, cannot be an appointment. In-charge principal in 1992 engaged the petitioner on honorary basis. Now, this will be, my lord, fortified by the next page, my lord. There is a letter of 13th of
yes,
June
to create a
1994,
post,
my lord,
to create a post.
for regularizing Phanindra Kumar Das, specifically stated. So, my lord, in a non-existing post, he was engaged, my lord, on honorary basis. Now, Lord, may kindly turn to page 23 for a moment, my lord. This is the pro forma SAR. Here, Lord, you will find the date of provincialization of the school. The school was
1/10/77.
provincialized from 1/10/1977. After the school is provincialized, my lord, if there is any vacancy or any vacancy is required, my lord, after having the approval of the at that point of time SLEC, they will have to advertise it. They will have to fill up by regular selection. Prior to provincialization, that's a different thing, my lord. Whoever is there, my lord, as per the rule, they will be provincialized. But in the present case, my lord, the inspector has been, my lord, after the engagement of the petition on honorary basis, have been, my lord, writing letters to the director for creation of a post. And
So,
whatever
Mr.
salary, my lord, was given to him, lord, you will find that order at page, my lord, 25. In a retirement vacancy.
Hmm.
An order was issued by the inspector of schools, my lord, that he will get a scale of pay. My lord, a honorary worker, my lord, cannot, but if at all he has got salary for few months, that is also illegal. Cannot get. 25.
So, Mr. Gogoi, we cannot save you. But then also if somebody is made to work, the school will have to,
That
Pay
will be
them.
upon the managing committee.
Managing
That is
committee
the
will have to-
minimum. That's otherwise.
minimum scale of pay has to be paid to them.
Not, it will not be a scale of pay, but liability will be upon the authorities who have engaged them.
Managing committee,
Managing committee. If they have got their own fund money, they will have to manage. But whether managing committee is a party or not, that. Yes, respondent 6, madam.
heard. Mr. J. Kalital and counsel for the petitioner. Mr. U. Sharma Lanet, standing counsel for the Secondary Education Department, appearing for respondent numbers 1, 2, 3, and 5.
No, not my lord, 5. Only 1, 2, and 3, my lord.
It's a provincial school, you have to appear for principal.
Principal.
You'll have to appear for them. And Mr. B. Gogoi Lanet, standing counsel for the Finance Department, appearing for respondent number 4. Next, madam. The case of the petitioner is that he was appointed on temporary basis on the leave vacancy of one Vinod Boishya as per where is this order by respondent number 3?
Lordship.
Page 20,
Page
my lord.
14. with type copy also. 28 March 1991.
Okay. By order dated, order and memo number EST -4. This is at page 14. Huh? Memo number is there. So and so dated 28/3/1991. Issued by the Inspector of Schools, Nalbari District Circle, Nalbari. First one.
Extension.
The it is projected that the service was extended by an order dated 19/4/1991 issued by the Inspector of Schools, Nalbari District Circle. Thereafter, the petitioner continued to serve the Paschim, Bonbhag BAN, BHAG, Bonbhag High School against as grateful employee. Of the night chowkidar of the school. First one. The petitioner claims that the principal of the said school, within bracket respondent number 5, issued an appointment letter to the petitioner on 5/1/1992, and the petitioner rejoined the said school. First one. The petitioner as well as the school authorities had written to the Director of Elementary Education, Secondary Education Assam, for sanctioning a grade 4 post in the said school and to regularize the service of the petitioner. However, the same has not been done till date. First, the learned counsel for the petitioner has submitted that from time to time the petitioner had drawn his salary, and lastly he was allowed to draw salary against the vacancy which arose out of retirement of one Krishna Deka from a grade 4 employee of Ganga Pukhuri, GNGA PUKHURI, Barkuria BARKURIAH High School, wide. Order dated 6/9/2004, with effect from 31/5/2002. Where is that order?
Page 25 was type copy, that's 26 is the original copy.
Which was issued by the Inspector of Schools, Nalbari. Accordingly, by filing this writ petition in the Article 226 of the Constitution of India, the petitioner has prayed for a direction upon the responding authorities to regularize his service with effect from 28/3/1991 and to release his area salary from 1/1/2006 till date. The learned counsel for the petitioner has submitted that the petitioner has been working in the said school from 28/3/1991. And despite rendering service for about 22 years, my service has not been regularized till date. It is also submitted that the representations of the petitioner have not been responded to. And it is also submitted that the petitioner has rendered, there we have, where you said 22 years of service without any break. Just add that, huh? In that part where we have said 22 years of service, there you add this, without any break. Heard these submissions made by Leonard Standing Counsel for the Secondary Education Department as well as the Finance Department from opposing the prayer made in the writ petition. Next paragraph. It is not in dispute that the school in which the petitioner is rendering service was provincialized with effect from 1/10/1977. Where is that act? The 77 Act?
Page 22,
And provincial acts.
data provincial is
1/10/77.
Yes,
1/10/70.
No, no,
Page
no,
22. Page 22.
no, that act is in which
Oh, yeah.
page?
352.
352. So the date of provincialization appears to be in consonance with the provision of section 1 within bracket 3 of the Assam Secondary Education within bracket Provincialization bracket close Act 1977. Which mandates that they said act shall come into force on 1/10/1977. First of all, the provision of section 2 within bracket 5 provides that within inverted comma, employee means a person in the employment of a school working against a regularly sanctioned post and whose appointment has been approved by the school authority wherever such approval was necessary. And as per section 2 within bracket Roman 12, school authority, inverted commas, means the director or inspector whose approval is necessary for appointment or regularization of the appointment of an employee of a secondary school. In light of the said definition, the court is of the considered opinion that the petitioner has not been able to demonstrate that the employment offered to him was in accordance with the scheme of the said 1977 Act. as per Section 3 within bracket 1 of the said 1977 Act, it is provided that all rules, including service rules and rules of conducts and discipline, which are applicable to government servant of corresponding ranks, shall be applicable to all the employees. In this regard, the petitioner has not been able to demonstrate that he was employed by following any service rules, by following and or in accordance with any service rules. So therefore, the employment to the petitioner was not offered in a transparent selection process. Mr. Sharma, where is the service rules corresponding to that 1977 Act? Which corresponding rules were being followed? Corresponding to that, corresponding to that Act 77, what are the rules? This school is a secondary school or a middle English school? The school of the petitioner,
Secondary school.
secondary school.
Secondary. Yes, sir. Second. Nineteen
1977 is the Act. What is the corresponding rules?
Rules will be 82.
No, 82 doesn't have that cadre. That's what I showed you.
Page, Lordship may see page 790.
790.
At the top of the notification. It speaks about the 77 rule. In exercise of the powers conferred by the provision of Article 309 and Constitution, the Governor of Assam is hereby pleased to make the following rules regulating the recruitment conditions of service of teachers of higher secondary school,
Teachers,
which have been, yes, provincialized under the.
teachers, not grade 4. That is what is intriguing me. Because the schedule 1 doesn't contain any
Yes,
grade
no,
4.
it's specifically for teachers.
This is
But the rules
specifically for
is
teacher. 82 can't be.
non-teaching staff.
Just try to find out, Mr. Sharma, so that we can add. Otherwise, this will be not complete. Just next para. Although the learned counsel for the petitioner, as well as the learned standing counsel for the secondary education department, has submitted that the 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 corresponding rule under the 1977 Act.
My lord, it is there, my lord, page 293. Proxima C, Assam, oh, it's elementary.
Elementary.
No,
That is elementary.
it's elementary.
Elementary.
Is the Assam secondary education within bracket provincialization bracket close service rules, 1982, comma, but
Single one division.
the said rules consists of cadres relating to only teachers or the teaching staff, including principal, graduate teacher, etc. And the schedules appended thereto relates to the cadre of teaching staff. Full stop. Full stop. Nonetheless, comma, be that as it may, as the 1977 Act provides for employment under the existing rules. Comma. The appointment of the petitioner on the vacancy would not constitute employment in accordance with law. First,
এখন আমি annex করছি।
next one. Although the petitioner has rendered quite a long
Annexed.
period of service for 22 years. But it is, the law in this regard is well settled in the case of Abdul Bari versus State of Assam and others, comma, 1999, within bracket 3, bracket close GLT 31, where it has been held by this court that persons appointed by the managing committee after the provincialization of school on honorary basis are not eligible for regularization. So they said judgment was also followed by the division bench of this court in the case of Dambarudhar Kavita versus State of Assam and others, comma, WA 252 of 2003, comma, decided on 17/6/2003. Next paragraph. Even otherwise, pursuant to the decision of the Supreme Court of India in the case of State Secretary of State of Karnataka versus Umadevi, 2006 for SCC 1. The petitioner would not be covered as a candidate eligible for regularization, having not been appointed in accordance with law. Next, accordingly, in view of the discussions above, this reparation fails and the same is dismissed. Next paragraph. Nonetheless, the court has noted with concern that the petitioner claims that he has not been paid his salary or remuneration from 1/1/2006 First, in this regard, the court is of the considered opinion that as the managing director, the managing committee of the Paschim Banobhag Higher Secondary School have extracted work from the petitioner, comma, the managing committee of the managing committee or the school managing committee, by whatever name called, of the said Paschim Banobhag Higher Secondary School would be liable to release the salary of the petitioner from their own funds, from out of their own funds. First of all, accordingly, the court permits the petitioner to submit a certified copy of the order of this court to the managing committee of Paschim Banobhag Higher Secondary School for release of the salary along with a certified copy of this order. And on receipt of the same from the said school authorities shall pay to the petitioner his due salary from out of their own funds. Within a extended period of 1 year, however, the payment shall be released in monthly installments spread over a period of 12 months. So within a year, they'll make that payment in monthly installments.
That clearly indicate, my lord, the respondent 5 and 6 has been represented by R.P. Borua. They are in the court list, who is not present today.
Who?
5 and 6 by R.P. Borua. All in the court list.
Okay, in the top you can write, although the cause list reflects the name of Mr. R.P.
Borua.
Barwa as counsel for respondent numbers 5 and 6, Miss R.P. Barwa, but none appears on call. So then, Mr. Sharma will not be appearing for 5. Principal.
I am not appearing for
No.
that.
5 will strike down. 5 will be by this counsel, Mr. R.P. Barwa. Okay.
My lord, in 2003 rules, my lord, probably, my lord, this grade 4 employees have been covered. 3 rules. 2003 rules. Page, my lord, 367. Both teaching and non-teaching staff has been covered.
367.
367. Rule 3, sub rule 2, my lord,
Okay,
367 at the bottom,
Okay,
the non-teaching staff.
oh, okay, that paragraph where we said that 82 rules are not covered. Instead of that, you write, it has been pointed out at the bar by the learned Stennicus for the secondary education department and learned Stennicus for the finance department that the non-teaching staff of provincialized secondary schools would be covered by the provisions of Assam secondary education within bracket provincialized bracket was service rules 2003, which provides for the manner of recruitment of grade 4 staff. Okay,
And my lord, in 1977, page 355, just one thing I would like to point out. Employees to be government servants. Lordship, you will see, my lord, sub rule 1. All rules, including service rules and rules of conduct and discipline. which
that I have already
are-
recorded.
Yes.
That I have already recorded.
Otherwise, my lord, it is a general rule at that point of time.
That I have already recorded. Okay.
May I please, your lordship?
If there is any confusion, type both of them, then I'll correct it.
May I please? Lordship, this direction is given to the managing committee also. To page 2006 also. It cannot be to the all respondent also. Direction may be given to all.
State can't pay.
It will also create another problem, lordship, because the managing director, managing committee has no such funds, lordship, to release the salary of the employee, lordship. And if the lordship, they fail to pay their salary, lordship, they will again have to approach before your lordship by way of contempt and all. So lordship, the managing committee will send one every year or after 2 years, lordship. It will another problem will create, lordship. And may I play?
No, that can't be helped. You see,
But
either
may I play
you
one-
have to, you see, I'll have to give you some avenue for salary. If I consider that, then this observation for your salary will also go.
Lordship, one
You
thing is-
see, somebody is extracting work from you without paying. Why would you have a soft corner for him? Let him go to jail.
May I pay one thing on lordship? If lordship, lordship may also lordship follow the order of lordship, Harendra Nath, lordship, Harendra Chandra Nath case, lordship, that may be lordship, yes. And the same judgment also followed in the same school, lordship. I am giving the same judgment, lordship. It is not, same school, lordship. Person one, not school, this petitioner also, lordship. And this court, lordship, division bench, lordship, follow this order, lordship. Yes, his service was utilized by the respondent, lordship, his salary for that period, lordship, by the respondent. Sir.
Nineteen 96. 2003. That is 2013 to 1990. 2013 to GL3.
One second.
না, এটা অলরেডি তো রিফ্লেক্ট করে দিলেন। রিফ্লেক্ট করেছে। এটা দ্বিতীয় রিফ্লেক্ট করবে।
Lordship, this is same fact, Lordship. In this petition also, Lordship, I was there, and actual fact is the same, Lordship. I can provide the Lordship single bench order also, as well the repetition.
It's okay, I'll take it from you,
Lordship.
but still I have to reject it.
Lordship, that must be considered because Lordship, same fact and circumstances this order was passed, Lordship.
No, I'll give my reasons to do it, because I have authored several judgments where if a person is illegally appointed,
Yes,
then I have denied the relief.
that's true, Lordship, but since his service has been upheld by the respondent, Lordship, minimum, Lordship, since Lordship 1992, Lordship, his service has been upheld by the respondent till today, Lordship. At least, Lordship, that
No,
must be.
that is okay. But since you want a direction on the state authorities, then I'll have to deal with it.
In this order, Lordship, directional issue.
No, I'll deal with it, don't worry. This last paragraph, how they have extracted salary, that will go. Next paragraph, in respect of the claim for area salary. Or the learned counsel to the petitioner has referred to the judgment by the division bench of this court in the case of Harendran Chandra Nath, HRENDRA CH Nath versus State of Tripura and others, 2013 within bracket 2 GLT 1094, whereby recovery of arrear salary was restricted to a period of 3 years prior to the date of filing of the writ petition. Reference is also made to the decision of the division bench of this court in the case of Mohammed MD, Mazid MZID Ali versus the state of Assam and others, WA 187 of 2018, which relates to claim of salary by a retired assistant teacher of the same school, i.e. Paschim Bonbhag High Secondary School. So it is submitted that in the SET's case, although the writ petition was dismissed, but in appeal, the division bench of this court had entertained the appeal only on the issue of entitlement of arrear salary with effect from 1/1/2006. The said order is extracted below. This is the order. This next paragraph. Accordingly, it is submitted that as the issue relating to payment of arrear salary of the same school is involved, this court should invoke the principle of parity and grant same relief to the petitioner. Next, coming to the claim made by the learned counsel to the petitioner for the arrear salary of the petitioner for the period from 1/1/2006. Date. As already mentioned hearing before. In this case, there is no material on record that the petitioner was appointed in a transparent recruitment process after advertising any vacancy. There is no record that a formal approval of the appointment was made by the competent authority in the secondary education department, which is the director or the inspector of schools. In light of such factual metrics, it would be relevant to refer to the case of State of Orissa and another versus Mamta Mohanty, MAMTA, Mohanty, MOHANTY, within bracket 2011, bracket was 3 SCC 436. Para 36 thereof is quoted below. This para 36 starts, therefore, it is a settled legal position. Then we find out in the, this will be the paragraph, and it ends on persons to compete on merit. Stop, invert comma closed. That is para 36. Next part. In the case of National Fertilizers Limited versus Somvir Singh, SOMVIR Singh, SINGH, within bracket 2006, bracket close 5 SCC 493, the observations made by the Supreme Court of India in para 23 to 26 are quoted below. Similar view was taken by the Supreme Court of India in the case of State of Manipur versus Y token TOKEN Singh within bracket 2007, bracket was 5 SCC 65, where it was held that if the claim is based on illegal appointment, the appointees are not entitled to receive any salary for the period during which they rendered work on the basis of such illegal appointment. A similar view has also been taken by this court in the case of Rukia, RUKIYA, Khatun versus State of Assam and others, 2012, within bracket 1, bracket was GLT 532, equivalent to, within bracket 2012, bracket close 4 NEJ 80, where this court has held that the court had held that the petitioners therein were the product of illegal appointments, and consequently they cannot claim payment of salary, and accordingly the petitions were dismissed. The said view has also been followed by this court in the case of Mohammed MD, Harunor, HARUNAR, Rashid, RASHID, versus State of Assam and others, 2019, within bracket 4, bracket was GLT 771, where by referring to the judgments referred hearing before, the claim towards salary was refused. Next paragraph. Be that as it may. Although the court is disinclined to issue any direction to the state respondents to make payment of the salary of the petitioner, but following the order dated 3/9/2018 passed by the division bench of this court in the case of Muhammad Majid MAZID Ali within bracket Supra, cited by the learned counsel for the petitioner. The court is inclined to provide that the school managing committee of Paschim Banbag High Secondary School shall be liable to pay the arrears salary of the petitioner, restricting the entitlement to a period of 3 years prior to the date of filing of the writ petition. Prior to just give the date prior to
19/4/17.
19/4/2017 or the date of filing of the writ petition. The payment of the salary to the petitioner shall be released by the school managing committee out of their own funds within a period of 6 months from the date of service of certified copy of this order before the Senate, before the school managing committee. So it is again reiterated that the liability shall not be on the state respondents to make this such payment.
Obliged.
I'll take a break and come back. Yeah, that's.
May I please, Your Lordship.
Yes,
Lordship, so far my instruction, Lordship, the relief aspect for by the petitioner has already been granted by the authority. But he has to submit one legal guardian declaration, Lordship, before the treasury officer for receiving the same. So actually, I think, Lordship, I have no case, Lordship. For that, I filed one Lordship application before the district judge, Lordship, for declaration of legal guardian, Lordship. So I will withdraw the case, Lordship.
Upon the instructions from Mr. S. Talukdar and counsel for the petitioner, submits that the petitioner has moved the district judge for a legal
Legal guardian. Declaration of
certificate,
legal guardian. Lordship.
legal guardian certificate. And accordingly, his instructions not to press this matter. Lordship. Mr. G. Pegula and Government Advocate, and Mr. A. Chukandan as standing counsel for the Elementary Education Department are present. Next. Matter since closed on the job. Obliged, Lords.
I am. Maybe, sorry. For the petitioner, there is a backlog, my lord. Already it's as per the advertisement of the social welfare department I have selected. The similar situated person already appointed, my lord. Only my post is not elected. Copy of the similar order passed by the.
Pass it on.
Earlier occasion, my lord, one poster already they have like vacant. The reserve for.
The only thing is that, my lord, that education department needs to be implemented, my lord.
That they have implemented.
Implementation, no?
Lordship, we haven't
As
been
per
made a
director of
party.
the
Nor haven't we have not been served any copy also. Our name has not been reflected in the cause list also, Lordship. Lordship peruses the cause list. I think, my lord, the elementary education is a necessary party in this matter.
They've implemented.
But my lord, in the cause list, it's not reflected, your lordship. Your lordship peruses the.
Okay. Can you give him a copy? Please give me a copy of the petition. Let him have the instructions. Because they will have to also have to tell us whether the vacancy is available or not. In that school.
Vacancy is available.
Okay, but still. Also, is a duly represented. Study person for the Elementary Education Department has submitted that though the Director of Elementary Education was incident by virtue of order dated 8/12/2017 and 10/12/2020. But a copy of the petition has not been served on him. And even a formal notice to the Elementary Education Department has not been issued. Next paragraph. According to the Learned Counsel for the petitioner shall provide a copy of the petition to the Learned Standing Counsel for the Elementary Education Department. Next paragraph. Let a formal notice issued on the newly implemented respondent number 5, i.e. the Director of Elementary Education Assam. Is made redundant. Give a fixed date after 4 weeks. Next paragraph. 14(6). The Learned Counsel for the petitioner has produced a copy of order dated 22/9/2017, passed by this court in WBC 362 of 2017. And it is submitted that the case of the petitioner would be covered by the said order. Let a copy of the said order be also provided to the London Standing Council for the Elementary Education Department to enable them to obtain instructions. The you can mention that this could by an order dated 8/12/2017 come as an interim measure directed that one post of ME school teacher in Dhubri district earmarked for visually impaired, physically disabled person, physically challenged person shall be kept vacant. The London Standing Council for the Elementary Education Department shall also obtain instructions if post has been kept vacant in terms of the said order. Next, this order, give a copy to him of this order also.
Lordship, just one thing, Lordship, the registry may reflect our name in the
Okay.
as
The registry shall reflect the name of SC Elementary Education while listing the matter next.
deeply obliged.
I'm returning you your copy. The next one you can give us. Yes, Mr. Atia.
Like that, my lord. Hearing maybe weeks.
Yes, you will start your argument. It's a 2018 matter.
My lord.
If you are ready, you can start argument.
Actually, I'm not well today, my lord.
Okay, then we'll fix another date then. All sides are duly represented.
Lordship, kindly fix a short date because college is suffering, Lordship, because of stay order, Lordship, of party.
Okay. The prayer made by Mr. A.J. Atiyal and counsel for the petitioner, the matter stands adjourned today. List the matter for hearing on, give a date after a week or 10 days. Give it on a hearing day.
18/5.
Yes, Lordship. Yes, Lordship.
Huh.
18/5.
You just add there, the case is ready, the service and pleadings are also exchanged. Based on sense of hearing.
All right.
This is also that net slet.
14.
Second half losses, as that's in second, this is another second half losses. I can
Very
put it
good.
from quotas loss.
Okay.
So
Second half loss.
let him come. I may be allowed to start.
No, start together because otherwise I have to carry that.
Second what you got. Second.
15.
May I please, your lordship,
Yes,
that this is that matter, lordship, electronic science and that.
electronic science.
Lordship, may kindly peruse the advertisement. It is specifically given that MA, MSc, MCom in the specific subject.
Very-
Page number 18, lordship, annexure
18.
2. Application. Applications are invited in standard form. So and so candidate having MA, MSc, MCom from a recognized university in the mentioned subjects. That means the advertisement was of lordship for physics. And the private respondent is having MSc degree in electronic science. And she was appointed lordship till that she is imparting lesson. I mean, she is continuing. And I am the candidate lordship second, I'm physics. candidate, MSc in physics. It is specific in the advertisement. It's said that in that specific subject. How they, and another thing is that, Lordship, this issue has already been decided by this honorable court in another writ petition, which I have mentioned, I mean, I have annexed in this writ petition, Lordship. In that writ petition, it is already decided that both are different and different subjects, and physics has wider aspects, Lordship.
Okay. Yes, you got instructions.
My lord, regarding the equivalent between the MSc Electronics Science and MSc Physics is the Director Secondary Education Department issued a letter, wrote a letter to the Academic Register, Guwahati University, and requested him to clarify as to whether the MSc in Electronics Science can be treated as equivalent to MSc Physics or not. Now, the matter is required to produce before the honorable court. This is thereafter, my lord, this matter is awaited. Now, no reply is coming from the Guwahati University, madam.
Obviously, if you ask that question, nobody can reply. You see, electronic science is equivalent to physics or not, if that question you ask someone, what will you reply?
It's still awaited, my lord.
No, I understand.
Yes.
But I'm trying to just understand.
Yes, yes.
If you put this question to anyone, can he give a reply?
It is an academic matter, my lord.
No, I understand, but still, can anyone give a reply? Is it equivalent? It can't be equivalent.
No.
Okay, yes, what do you have to say?
Education will later in discuss.
Hmm?
Education will later in discuss. Also, education will.
Okay. Yes, Mr. Goswami.
Sorry, but your lordship was pleased to direct them to produce some instruction.
They're just writing letters. It will never come.
No, I mean, university still awaited. Reply is still awaited.
You decided because nobody can decide this issue. Equivalency cannot be decided by the university. Because equivalency is always decided by the education department.
Yes.
Not by the university.
I don't know why they have written to.
Equivalency is always decided by the state, not by a third party. The Assam government did not write to the university that we are appointing clarification, if any, be given by you.
The director has written to the government in the education department. Right, to director.
Director to academic.
4, 5.
It's okay, we'll decide on merit.
Let the director reply, let the director.
They won't be able to now in writing letter, that means he
My
does
lord.
not know. You see, once the director is writing to someone else, that means he does not know the answer.
Apparently.
So we'll decide it.
Director है कौन वो एक हमारा appointing director.
The director is wash off his hands. He has given it to a third party. Now, third party opinion, whether the court will accept or not, is the prerogative of the court. Third party opinion we may accept, we may not accept. Because Mr. Goswami, I have a simple example. Now,
The director, unless the director speaks up, my lord,
No,
we cannot.
you see, I have a very simple example. I have full faith in the Vedic system of education,
My lord.
correct? No, it's just an example. It's not right that I do have that conviction. But it's just a measure of example I am telling you. I have full faith in the Vedic system of what do you call the knowledge. Now there, I find that sages of those times, they could do arithmetic, they could do physics, they could do what you call this medical science. They could calculate the movement of stars so accurately that the Panchang is correct even now. When the when the movement of Earth has slowed down by a the scientists now say that the movement of the Earth has slowed down. Still, the Panchang is always correct.
Right.
So I think that a man who has done meditation has a wisdom of all branches of education. He will know arithmetic, he will know physics, he will know chemistry, he will know anatomy, medical science, he will know astronomy, he will know astrophysics, everything he knows. That is my conviction.
Right.
So with that conviction, can I direct the university to now start taking into employment all the lecturers and professors only who have done who have undertaken meditation in the Vedic science? And if I ask that question to anyone, that whether Vedic person with Vedic knowledge is equivalent to physics, what will someone reply?
Exactly, but this is for the experts, the competent authority to, my lord, punish their stand or the reply.
No, since he has not done it, now we'll hear the matter.
Maybe your lordship can allow him, my lord, 2-3 days time, at least this time.
No,
Because it is from Guwahati only.
no, you see, an expert opinion, we never asked. So under 45 of the Evidence Act, if the court requires that evidence, then it may be brought on record. But now if supposing anybody comes,
Direction has gone.
I understand, but if someone comes and says, I'll give the court an opinion, but let me take the opinion from a third party. Third party opinion may be palatable to the court, may not be, because we did not direct.
But the director has to come, and I think director is the appointing authority at the same
No,
time.
that's why you say,
So they have to.
Mr. Goswami, you see, there are two things. Number one, we did not ask for an expert opinion. We asked the director,
Exactly.
and the director now is saying that a third party will give an opinion. That third party opinion may be acceptable to the court because we did not direct him to take a third party opinion.
Or
Because if the court wants a third party opinion, we'll form our own opinion. Who is the expert?
yes, exactly. Exactly.
So university academic registrar, without knowing his qualification, I can't accept his statement to be the last authority. He may be like me. He may be like me, accepting the Vedic science as equivalent to all branches of law.
No, but see, the direction has gone from this court, my lord, he should have. It's like, because he is the appointing authority, now he is going to another authority, as if he doesn't know.
So, my lord, some time is required to get the.
No,
reply,
we are
then
not
they will
doubting.
decide, my lord.
No, director, we are not giving time. If the director does not know what to do, what is the point in giving them time? He's a director of higher education, what is it? Secondary education. He gives an appointment and doesn't know what he's doing. No point waiting for his opinion. In the court proceeding, we must have a guided missile, not unguided missile.
Yes.
You just fire in the air and where it will go, we don't know. That is not how we proceed in the matter.
Then my lord, as per advertisement, it will,
So we'll decide the issue.
yes, already decided upon that.
Mr. Goswami, any supplementary argument you want to do?
My lord, Guwahati University, my lord. This has just been handed over to me, my lord. This is signed, my lord. This is digitally downloaded, my lord. Signed academic register, Guwahati University. My lord, list of allied subjects, my lord. It's a list, my lord. Got a copy of it. Got a copy of it. Physics, no? All various subjects have been mentioned, my lord. Amongst them, my lord, physics is there at serial 38. That will be the third page.
Yes.
Your lordship will see, my lord. At serial 38,
Yes.
physics. It includes astrophysics, astronomy, biophysics, electronic science, instrumentation, material science, mathematics, nanoscience, nanophysics, nanotechnology, physical science, radiological physics, etc. So electronic science is mentioned there as one of the allied subjects. And this is from the academic register, Guwahati University. Possibly, if the director approaches him, also only this instruction will come, my lord. I'm not certain, my lord. And my lord, in our affidavit,
Just a moment. We have a connection with another know-all, which is Google. As per Google, curriculum of electronics sciences includes analog electronics, communication, electromagnetic, digital system design, mathematics, and optoelectronics. As per the UGC, the electronic science syllabus is having code number 88. Unit 1 includes introduction to semiconductor, energy bands in solid, concept of effective mass, density of states, Fermi levels, PN junction, diode equation, diode equivalent circuit, breakdown in diodes, Zener diode, tunnel diode, metal semiconductor junction, OH, MIC, and Schottky contacts, characteristics and equivalent circuits of JFET, MOSFET, low dimensional semiconductor devices, quantum wells, quantum wires, quantum dots, high electron mobility transistor, solar cells, IV characteristics, fill factor and efficiency, LED, LCD, and flexible display devices, emerging materials for future devices, graphene, carbon nanotubes. Correct. There are 10 units. Which all includes transducers, power devices, analog modulation and demolition, electrostatics, microprocessor, logic families, rectifiers, voltage regulated ICs, superpositions, fabrication, and in undergraduate level, physics includes electricity and magnetism, space and time, thermodynamics, quantum physics, relativity, geophysics, fluid dynamics, astronomy and geology.
My graduation is in physics. Only post
No,
graduation.
graduation may be in physics, but that doesn't mean that the
But in many places, my lord, like this is the case, my lord, Haryana Staff Selection Commission. They give education qualification for post of PGT physics as MSc physics, applied physics,
no, that is okay. We also have
nuclear
that.
physics and electronic science.
That we also have in APSC. If you have are a astrophysics, you may be appointed as a finance secretary.
No. In the
Yes, we follow it.
result,
There's no difficulty in it.
result.
I've got nothing to do with physics, chemistry, and then this computer science, and I'm deciding that issue.
Well,
So there's got nothing to do with it. Qualification has got nothing to do with it. Now you know this MIT,
yes.
Massachusetts
Mm.
Institute of Technology.
Mm.
Their physics subjects include time and space, straight line kinematics, motion in a plane, forces and static equilibrium, particle dynamics, force and conservation of momentum, relative inertial frames, and non-interior force, potential energy, conservation of energy, kinetic theory, ideal gas, rigid bodies, rotational dynamics, vibrational motion, conservation of angular momentum, central force motions, fluid mechanics. Subjects taught by using TEAL, technology enabled active learning format. That is why they are world number one.
They are way advanced.
India is nowhere near to it.
But we also had a very richer, my lord, history.
No, I'm not comparing anything,
Yes.
but I'm saying that this is what they are teaching in MIT in physics 1.
And our IITs and IIS will also have such curriculum. They are
No,
also
correct.
very advanced.
I'm not comparing
Yes.
anything, but that's why I'm saying that is why they are number one. MIT. Okay, then we close the matter. We'll have-
My lord, your lordship will kindly note that, my lord, in the same line, my lord. I have in my additional affidavit, I have the next document, my lord. Even Himachal Pradesh also,
Where is that
that is at
page?
page 21, my lord.
No, running
Keep-
page.
keep-
Running page would be how
Of
much?
the additional affidavit by R5 that is dated 10/5/2023. And Annexure 1 by the Himachal Pradesh Public Service Commission.
You file it when?
It was filed on 10th of May, man.
Additional affidavit.
It was the 10th of May. Additional affidavit, no? 10th of May, man. 2nd of May, man. 2nd May, man. 2023.
Additional affidavit by respondent number 5.
My.
You filed it when, Mr. Goswami?
2/5, man.
2/5.
Yes, man. 2/5/23.
Ah, yes. Which page?
That is, man, page 7, cumulative 83, man. Annexure 1. Himachal Pradesh Public Service Commission.
Yes.
Here, your lordship will find at page 2, madam. Next page, madam.
Yes.
Postgraduate teacher physics includes physics, stroke electronics.
Which serial number?
That is my serial number. That will be Roman 5, madam.
Roman 5.
Yeah,
Yes.
in the column of essential qualification.
Yes.
It includes physics, electronics, and nuclear physics. Then, my lord, in page 21, my lord. Page 21.
Yes.
Here, my lord, your lordship will find below, my lord, the bottom part, my lord, 687 posts include 98 posts of background of TGT physics teachers. Your lordship will find educational qualification, MSc physics, or applied physics, or nuclear physics, or electronic science.
Yes.
Then, my lord, Then my lord, page 35, my lord. My lord, there is a body called Department of Atomic Energy, my lord. They have got different installations all over the country. And they have their own education society. And they have their own schools, my lord. Your lordship can come to page 34 and then page 35, my lord. Page 35. Bottom part.
Page 35, yes.
My lord, bottom part, my lord, the subjects are laid down. Post and subject. Your lordship will find 1, 2, 3. Fourth line, my lord. EGT physics.
Yes,
Post graduation in physics or electronics or applied physics or nuclear physics. Then, my lord. I have already placed, my lord, this was, my lord, Haryana.
just a moment.
Haryana copy में ध्यान है। Here नहीं तो है। ये तो एक छोटे को भी। ये तो असली नहीं। चलेंगे फिर भी तो असली नहीं। कौन कर रहा है? Hmm? 24. Kung pwede nila. Ayan. 94. Ay, ano deposit? Ito. Ito. Yan ang notice. Ito develop ito. Ano? Ito yung ito develop. Ito develop ito. 127. Electronics is physics, applied physics, nuclear physics, electronics.
Your degrees from which college?
My lord,
The computer science degree is from which college? Or which university?
oh, myself, my lord.
Yes,
What about the education?
She's from Guwahati University.
Education qualification. Guwahati University.
Guwahati University. Your mark sheets are there.
Yes, I have annexed. Lord.
Where is that?
Page number 25, read petition, Lordship.
25.
Lordship.
My lord, in my affidavit in opposition, I have given, my lord.
It's okay, wherever it is. Page 25, she says.
Yes, Lord. I have annexed 25, Lordship.
I have given my
Connection.
first certificate,
Page number 25.
first certificate and mark sheet.
Mark sheet is that.
Page 25.
25, annexure 5.
The comparative marks. I've been defined. Comparative.
Oh, this is semester. The subjects I am not, I don't find.
My lord,
Lordship.
What are the subjects?
It is their Lordship. Timpi Bora, so class 4th semester, Master MSc, Electronic Science.
No, no, fourth semester I understand, but
No.
fourth semester consists of which subjects I don't know.
Electronic science is there.
No, no. You see, electronics, electronics, maybe that they are teaching English also, we don't know.
Lordship.
I just want what is the semester breakup?
Semester breakup.
There are 4 semesters in MSc Lordship.
What are the subjects
2
in
years?
one what is the subjects are in one semester?
Lordship, it is reflected in the mark sheet, Lordship.
Yes,
Lordship, the subjects are reflected, Lordship.
no, this is only elective two.
Lordship.
Elective two, if you take,
Move to go.
then
I go to go.
she has taken OC. OC means optical communication, that much I understand.
Lordship. And the certificate is also there, Lordship, page number 26,
No, no, you see, I don't know the subjects.
Lordship. What my submission
see,
is,
Ms. Kango, supposing you open a university,
Lordship,
you give a degree of physics,
Lordship,
and then the subjects are English, Hindi, Assamese, Bengali,
yes.
and you say that this is in my university, it is physics. I don't know. I just wanted to know the subjects. According to your dictionary, maybe physics is English.
In bottom part, Lordship, EL1 digital signal processing, advanced microwave
No, 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 no.
communications. Those are
Before
there.
coming to that, last line you read the earlier line.
Okay.
Earlier line says elective two is one of the following subjects.
Lordship,
When I read the paper, I read it correctly. Don't worry.
Lordship.
So this
My,
is,
my,
and here in that page 25,
Lordship,
left side 81, she gets in OC. OC is optical communication.
Lordship,
So therefore, there is no difficulty in understanding those.
Lordship.
I only wanted to know the subjects which are there in semester 1, semester 2, semester 3, semester 4.
The petitioner obtained this by Lordship RTI. My humble submission before a Lordship is that, Lordship, regarding this additional affidavit, Lordship, my senior friend is indicating that this advertisement regarding this Roman 5 Lordship, postgraduate teacher, physics, electronics, the obliques are there, Lordship. In our advertisement, there is no scope of that, Lordship. It was mentioned that in concerned subject and subject was physics. In this advertisement, there are some options which are mentioned in the advertisement. The Himachal Pradesh Public Service Commission advertised this advertisement, Lordship. In their advertisement, column 5, there are some options. In our advertisement, there wasn't any option. It is specifically there that MSc in the specific
No, no, that
subject.
point I have understood. There is no
Lordship.
difficulty in that. But what are the subjects?
And my academic qualification also I have annexed, Lordship.
Madam, my fourth semester, my lord, I can place my name.
Yes, no,
1,
that,
2, 3, I don't think I have one. That is a part of the affidavit filed by me, madam.
yes.
No, this, no, my lord, I'm sorry, my lord, this is the
My
repetition
certificate
itself, my lord, page number 25. Page 25. my lord.
Give the running page so that it's easier for me to find out.
Page 25 is fourth semester. 1, 2, 3 is not there. And below, my lord,
Page, give me the running page so that it is easier for me to find out.
this will be 25. It will be 25, my lord, read petition. This is not the
Read
affidavit.
petition.
Oh, acha,
Lordship.
okay, 25 read petition. Okay.
25 read petition. This is the fourth semester mark sheet. Master of Science.
Fourth
in
semester mark sheets are always a combination of all
All the
semesters.
semesters.
But below, my lord,
It's not a standalone.
yeah, elective 2 is one of the following subjects. That is
No, that
mark.
is- that
Your
is
lordship
only-
has already did optical communication. Apart from that, don't have one thing. About qualification.
Okay.
We will go by our advertisement, Lordship.
It's okay. Please let Mr. Goswami complete.
And-
We have
and-
heard you on
Lordship.
that point.
And my lord, a comparative state, it is a PVT interview. A comparative statement is given at page 28. Dimpy Bora and Suraj Bebe.
your lordship can at least have a look at the comparative marks from higher secondary onwards. Higher secondary, BSc, MSc, B.Ed and CAT. Overall, my marks are better. And this is also, my lord, these marks were given by at the interview, my lord. It is signed by the chairman of the selection committee and other members, member secretary,
No, just a moment.
subject expert.
Mr. Goswami, as per the Guwahati University syllabus
Yes, ma'am.
for electronic science, in the first semester, it is concept of OOP, Advanced Computer Organization and Architecture, Operating System, Mathematical Foundations of Computer Science. I'm asking you for a specific reason because there are certain things I understand. You see, it is only in the, so far as my limited knowledge goes, it is only the Christ University, Christ College in Bangalore, which gives a combination subject of physics and computer science as a combination subject.
Okay.
In none of the universities I know of, they offer this combination subject. Therefore, I have that information and therefore I am asking this question for a specific purpose. So second semester is data communication, computer network, algorithms, software engineering, computer graphics, multimedia, advanced data structure, theory of computations, distributed system, compiler design, seminar. Fourth semester, it is programming language and project work. Fifth semester is advanced concept in OOP. Then comes instruction state architecture, computer arithmetic, processor design, memory, input output system, parallel architectures, advanced concepts. Therefore, nothing to do with physics. There's no core subject in any of the semesters with physics. Okay. So Mr. Goswami will decide it.
My lord, I'll leave it to you also. my lord. And I was duly appointed, my lord, my appointment order was part of record. And I have been serving since 2018, my lord. And my results of my students have been good. That also I have given.
we have all have seen in our life, some teachers who are not instrumental in very good marks achieved by a student.
Well,
No, I'm not saying that.
everywhere.
No, that's what I'm saying. We have all had a cup of tea. We have all seen,
But my lord,
as a student, you have also seen. As a
This
student,
that I
was
have
also
given
seen.
would show, my lord. Most of the students have achieved first division only. It is very nice. And my lord, the other documents that they have accepted, my lord, in most of these institutions that for PGT teacher. My lord, if we have a degree in electronics science, postgraduate, my lord. And electronic science I cannot do without doing, my lord, graduation in physics, my lord.
No, that is correct.
That is correct.
No, nobody denying it.
Yes, my lord.
You see, you.
And these are very advanced
Let me
institutions.
say, can they be an extended argument? I'm just, it's in a lighter mode, lighter note. Can it be an extension of argument that, well, I could do my graduation only when I passed my nursery, and in nursery we were taught drawing. So therefore, even fine arts I can teach.
No, but then,
No, I understand. You see, having a course in a graduation, then let us say what happens if a person does his engineering, does his MBA, and
Well-
then shifts and takes a degree in what you call engineering. I have a lot of friends whose elementary degree is one in what you call engineering, and then they have all migrated to MBA, taken an MBA degree from very good universities.
but
And
they cannot do, my lord, engineering without having a science in 10th standard.
no, I get it.
That
No,
is my
sure.
argument. my
No,
lord.
I understand. But
I
you
can
see,
do MBA even with geology. But I cannot do electronic science without physics. In the graduation.
correct.
That's what I'm trying to.
But that's you see, that's what I'm asking you. You see, if you have changed the streams,
Madam. Madam,
if you change the streams, it is not advertised that one having a degree
madam,
at undergraduate level, having a degree of science, will be able to teach science requiring a postgraduate degree.
may not be, but my lord, these documents show that electronic science, my lord. If not, I do not know, my lord. I am not an expert, my lord. I cannot say, my lord, except
No, you go to
also
the
I cannot
advertisement,
say.
go by the advertisement. You read the advertisement
Yes,
and what
but
does it
the
say?
advertisement is there, but the other advertisement in other, these are also very prestigious institutions, my lord. They have put / physics / postgraduate degree in physics / electronic science and some other science. That's a different. But
then,
for
Mr. Goswami,
PGT, that is a requirement for
No,
PGT.
just please tell us, can there be an appointment contrary to the prescription in the?
No, actually, that
advertisement?
was for them to answer, madam. I am at the receiving end, madam. I was selected by them, your lordship. That selection document is also placed before your lordship. That is there in my affidavit. I've just taken your lordship through that, madam. And there is a subject expert, madam. I have seen it today only. Signed by subject expert. No,
You read today's-
other members are there, apart that beside
You
my
have
lord.
read today's newspaper.
My lord?
You have read today's newspaper, Times of India.
No, ma'am.
There's a front page news today. I forgot it is today or yesterday. There was a discrepancy in the selection of a lecturer in KK Handy Open University. Just find out. And in that there was a discrepancy in appointment, and the subject experts have been banned by the state of Assam for any future reference. Either today or yesterday. Either today or yesterday. There's a front page news in
I'll
Times of
check,
India.
I'll check.
KK Handy Open University, there's a scam regarding appointment of one of the teachers. Just find out.
And my lord, I had also annexed one certificate, my lord, at page 14 of the affidavit filed by me. This certificate is by
Just a moment.
my lord.
No, that name is not coming up. Okay, it's not coming up. Okay, you are saying.
Yes, my
referring
lord,
to-
page 14 of my
Give the running page.
affidavit, my lord.
Give
My
the
lord,
running page.
page, my lord. Running page 9. It was filed earlier, my lord.
Yeah, earlier affidavit.
No, yes, my lord. It was filed earlier, so the running pages are not there. Annexure F, it's page 14.
Page 14.
Yes, my lord, of that affidavit.
Yes. And there.
This is certificate by one professor, Dr. Tulsi so and so, Department of Electronics and Communication Technology of Guwahati University. This is to certify that any candidate having MSc degree in electronic science may be considered for recruitment for teaching or non-teaching post in the Department of Physics in any schools / college.
Now, which law has authorized him to give this certificate?
My lord,
Which law authorizes him to give that certificate? You see, tomorrow somebody may bring a Gangura certificate
my lord.
saying that this what you call chemistry teacher can teach fishery.
My lord, no, my lord, this is, my lord, he is an expert, apparently from the document,
No.
Department of
No, somebody,
Electronics and
you see,
Communication.
somebody must have appointed him as an expert.
Yes,
Otherwise, you see certificates, then why the entire state is what you call making an agitation when this Gambura gives a certificate that he is an Indian citizen? Why everybody
competent authorities have been identified,
have been identified? So therefore, I am asking
my lord.
that if a citizen can't take two stand,
Exactly.
if it comes
That-
to a
that
Bangladeshi
is
certificate, then
correct,
you
my
are
lord.
aggrieved.
That is
If
correct.
it comes to a certificate by somebody else who say Gambura certificate giving that physics can teach, chemistry can teach what you call fishery, then you are accepting it. It can't be two standards. That is why I say opinion of an expert within the meaning of section 45 of the
Actually, my
Ethics
lord,
Act.
the director should have come forward and, my lord,
Opinion of an
make
expert
stand.
is defined under
the
45.
appointing authority should have come.
If the court wants an opinion of the expert, then we can take it. But if I don't need it, that's why you see under Order 26, Rule 9 and 10,
Then,
we have the site visit. We do it because the court wants it. If the court doesn't want an expert opinion, why will you take it? The difficulty is there. Because tomorrow anybody may come and give any certificate. I don't have as a court, we don't have a standard in saying who are an accredited expert that we don't know. This person, you see, he is from head of the Department of Electronics and Communication.
my lord,
So he will always say electronics people can be adjusted anywhere.
But
You see, in every college.
What I-
Mr. Goswami,
what
there is
I'd
a
like-
reason for saying that. It's not unnecessary. You see, in the law curriculum, every law student must attend what you
certain
call,
number of days.
certain numbers of what you call the
140 days.
court proceedings they'll have to watch.
Yes,
Internship they will have to do.
yes.
Correct. So they go to go for internship mandatorily. It's required under the law, so therefore they do it. And therefore, if they go to a good lawyer, they get a good CV for themselves.
Yes.
That somebody says that I have been with Advocate X. We give them regard because of the fact that he has been with Advocate
Yes.
X. There are students, law students today also in the room. They are coming here to gain an experience, and it will be a part of their CV saying that they have done internship with this
August institution,
this
yes.
institution. So therefore, you see, a person always will try to promote his own community. Because if he has given some what you call historical evidence saying that an electronics can teach physics, I can understand historical evidence has been given. Otherwise, everybody becomes an expert. Gambura can give a certificate.
So, but your lordship's direction was straightforward and specific, madam, to the director appointing authority. He should have come forward and he should have,
No, you take count of it. But this certificate.
he again, my lord, asked some other authority.
A certificate can only be an evidence of what already exists. Correct. Somebody gets married. His marriage is registered. That registrar can give a certificate that he is married.
To that effect.
But if a Gambura starts giving a certificate that yes, I know that they are married, it is not an acceptable certificate. And therefore, the certificate which creates an evidence is no evidence at all.
Correct.
But if it is a record of an investigation, and that forms a certificate, like in forensic evidence, there's a bullet shot. That bullet forensic is done, and it says that this is the bullet which was fired.
Madam, when someone is in water, madam, doesn't know how to swim, he will try to grab hold of anything, madam, even a hair.
No, Mr. Goswami, we give you more credit for that. We respect your what you call your stature.
But honestly, my lord, I would have, my lord, liked, my lord, if the director was here and.
Okay. Yes, anything in reply?
No, Lordship, I have already stated that my learned senior friend has referred that advertisement, that of the mentioned in column 5, Lordship. There are options are there. In our advertisement, there wasn't any option. The subject was physics, Lordship, and had it been that there wasn't any candidate of physics, they appointed electronic. I was there, Lordship. Physics student was there very much. Even then they appointed electronic science candidate.
Okay.
In absence of any physics candidate, that can be understood.
Yes, can go and counsel to the petitioner. You shall not study courses for the secondary education department. And number 1, 2, and 3. Mr. Sharma, for 1, 2, and 3.
1, 2, and 3.
And Mr.
I'm for 5.
BD Goswami, council appearing for respondent number 5. Who's for 4? Who's 4?
For one day,
No,
Lordship,
what is the name of the party? 4. Who is 4?
party principal come member secretary of
Principal and
CF.
members.
Who was it?
Okay,
Principal of that particular school, man.
okay.
More has-
Respondent number 4 remains unrepresented. Argument is complete, judgment is given.
I don't know.
Okay. I'll continue at 2.
Noted.
Lordship, I have a prayer. I have a prayer. I cannot, I have some personal problem. I have to. I have got a responsibility.
Item,
22.
you have informed the other side?
Yes, sir.
Under petition order.
Okay. Okay, where this has come for orders? Mr. Ansari?
Not yet admitted. Not yet
It
admitted.
is ready for admission.
Yes,
Then we can admit it and post it for hearing.
yes,
Lordship,
all right.
that can be done. I have filed my reply also.
Okay, all parties have appeared.
All parties are.
Huh?
All elected.
Okay. Mr. M. H. Ansari, counsel for the petitioner. Ms. E. Burman, counsel for respondent number 4 to 6 and 8 to 15. Sorry, 3 to 6 and 8 to 15 and 17 to 21. And Mr. S. Bora, Leonard,
1 and 2.
is study counsel for respondent number 1 and 2 are present. Next para. The learned counsel for all sides have jointly submitted that the case is otherwise ready for hearing as case is ready as regards service and readings have been exchanged. Full stop. Just give this file 22. So accordingly. In view of the nature of dispute raised in this petition, the request has admitted for hearing. By issuing rule returnable forthwith without requiring the petitioner to take first steps. List the matter for hearing on, give a date for hearing, fixed date. (19-6). So at there, as per order of Laozima Court dated 19/5/2017, service of notice on respondent number 7 is. The notice is really served on respondent 7, none appears on call for respondent 7. Okay. That's what we're hearing then.
Oh, 42 have handle.
Qualified candidates having MA, MSc from a recognized university in the subject is BEd, MCD, applicable. Filling out the following postgraduate teachers in the following regional schools.
Annexure 5, page 22. Let's we kindly see Annexure 5, page 22. On 16/8/2012, the director hired requested the principal to advertise the post lordship. Lordship got in the page 22, Annexure 5. Now, this has been issued in reference to government letter dated 6/10/2005. Lordship may kindly see the
Yes,
reference.
Mr. Das,
Yes, madam.
if the post is what you call sanction post
Yes, madam.
and the advertisements are held, what is the difficulty in giving an approval?
Simply they're saying that
My
there
lord,
is no
as per
approval. on the
inspection, my
tender.
lord, SUI if approval is not taken, my lord. From the finance and without that.
No,
approval,
you see, if the post is there,
Yes, ma'am.
then what you require is an order for what you call that
Approval.
no, the what you call the retention of the post, and when it's a permanent post, you don't have to take a retention every
Yes.
time.
It is exactly my case. Now.
Yes,
Regarding SIU approval also, they have to send a proposal to the SIU. my lord.
for a post which is which is sanction post.
For lordship, that can be, it can be considered for, because the first salary has to be paid by the SIU, my lords. So the treasury officer will also have to get involved. But whether or not they have sent any such proposal, my lord,
Even for a sanction post.
lordship, first salary, my lords, the procedure is there, like the first salary has to be paid under the.
So we'll ask the interdepartmental authorities to interact with each other and give the approval,
That is
SIU
what-
approval
as whether any
within a period
proposal
of
has
3
been-
months. No, if they have not done it now today with the order of the court, they will do it.
That can be done.
Because if the sanction post is there,
Yes, sir.
I don't find that the approvals would be required.
Lords, as per lordship, the first salary is paid by the finance, but for the record, my lords. After that, pursuant to that, it is being paid by the, so, lordship, the approval is taken, my lord. And no such proposal has been sent, my lords, from what transpires from the affidavit, my lords, of the higher education, my lords. In para 11, they have stated that regarding non-approval of appointment of the red petitioner is concerned, deponent begs to state that at that time of according approval in 2014, no approval was taken from finance SIU department. So finance SIU department was not even aware, my lords.
Lordship, two posts are filled vacant. One is lordship for reserved for OBC.
Do it in a time bound manner. 3 months' time, I think would be sufficient. The interdepartmental will have, what else say is that the interdepartmental heads, whoever are required, finance or any other finance personnel, any department who are required, they'll have a joint meeting and they will do it.
That can be done.
And if the officers in any of the department don't put up the proposal, then I'll ask you to refer the matter to the chief secretary for drawing up a disciplinary proceeding against them or head of the department. Otherwise, they will not do it.
That is
People are-
lordship, because finance SIU, I'm not even aware, like they might not be aware of this condition only because there's no proposal, my lord. For
No, but if
approval.
it's a sanction post, how the state can come and say that we are not aware of the post?
No, lordship, because
Post is
they have to seek approval, my lords. That is all, my lords, because it might be lying vacant.
You know the
also.
controversy now going on in Karnataka.
Yes, sir.
You are following it.
And
An advertisement came, rate cards were displayed. You're aware of the, no,
no, lordship.
so much of hue and cry. You just watch that advertisement by one of the political parties in the election campaigning in Karnataka. Just watch that. You can, state can implement it here also. For every work done, there would be a rate card displayed. You want an SIU approval? You want a driving license? For everything, there's a prepaid service. You see, it's so strange that a government approves a sanction the post and then says that, well, the first salary will be paid by X. Why? There should be a centralized system where if salary is paid by paid for the first time, it should go to your records automatically.
Maybe
It's a
after
push pull,
retirement,
it's a
Actually,
push pull
lordship,
service.
Once the appointment.
maybe after retirement, as the post fell vacant, my lord. Then thereafter for fresh
Yes, my lord, but
salary.
it was vacant post, my lord. That is why it was not filled up at that moment. It was a vacant post, my lord. So
During the during
vacancy
the
period-
time when the post vacant, my lord, no salary has been paid. No. For paying another salary, my lord, for fresh. The SIU approval.
It's
is
okay,
there.
but do it within a time frame. 3 months' time is
Yes,
okay, I
yes,
think.
that can be done.
But Mr. Edekal and counsel for the petitioner also heard Mr. S.
Yes, sir.
Das, Leonard, standing counsel for the Higher Education Department, appearing for respondent number 1 and 2.
my lord.
For 3 also, principal.
I'm for 3 months.
You are for 3. Your name?
Either.
D. Das. Leonard counsel for respondent number 3. And Mr. A. Shalia, Leonard, standing also for the Finance Department, within bracket respondent number 4.
Respondent number 5 is. Because 4 is, as per the petition is.
No, this Rabha has been struck off.
I apologize.
No, it's okay. You don't apologize, but it's been struck off. Next para. In view of the nature of just say, by filing this application under Article 226 of the Constitution of India, the petitioner has prayed for a direction to the respondent number 2 to grant approval for the appointment. The respondent number 2 means Director Higher Education, within bracket respondent number 2, to approve the appointment of the petitioner on his selection and selection for the post of, what is the post? The grade 4.
Grade 4, Lordship,
Grade 4 post.
reserved for OBC category.
As approved and confirmed by the governing body of the JN College Boko by resolution number 3.1 taken in its meeting held on 15/11/2014. The basic facts which are not disputed is that the petitioner was appointed as a contractual grade 4 staff in the said JN College. Where is this college? JN College?
Boko, Lordship, Kamrup Rural.
Okay, Boko.
It is reflected in the appointment order, Annex 3, page 20, Lordship. Boko, Kamrup Rural. Jawaharlal Nehru College.
The said post was advertised. The said was advertised for being filled up on 15/9/2014. And as per the advertisement, the post was reserved for OBC/MOBC candidate. The petitioner who is an OBC category candidate was selected for appointment It is also projected that in the meanwhile, another great. No, 2 posts were advertised, right?
Yes, yes.
Okay, so 2 posts were advertised.
So Annex 7 is the advertisement. Page 25. Type copy.
This is for one post. Petitioner is for one post. We can OBC candidate. Post of the resolution taken by the governing body along with a proposal for approval of the appointment of the petitioner was sent to the competent authorities of the Secondary Education Department. No, this is a higher education.
Higher education.
Higher Education Department.
Annex 10, page 34. On 1911, they
On
forward.
1911. What is the date? 19?
19 November 2014. Page 34, Annex 10.
1911, 2014, which was followed by reminder dated 26/8/2016, 15/8/2016, 15/5/2017, But the approval was not received. First of the petitioner projects that out of the said advertisement, the appointment of one Dharmaraj Dharmaraj Rabha was approved on 24/8/2015. So it is submitted that although the petitioner is working in the said college, he has not received a salary.
Not yet.
He has not received his salary from when?
So in fact, Lordship, what happened after this interview, I am Lordship, again Lordship dismissed from service by the college of that last annex 16. 20
From the-
September 2018, without
from
serving
the-
any notice.
From the date of appointment till he was,
After filing this writ petition, they have issued this. After filing this writ petition,
where is that?
that annexes 16, page 42. The principal written dismissal of service as per decision of so
Okay,
and so,
till he was dismissed from service
without any serve notice.
with effect from 21/9/2018 by virtue of an order of a letter dated 29/2018 issued by the principal, JN College Boko. First of all, it is submitted that while removing the petitioner from service, no proceedings was drawn up, and the petitioner was removed from service without giving him an opportunity of being heard. Full stop. The
I look that this is dismissal has not been challenged. My lord.
no. The Learned Standing Council for the Higher Education Department has referred to the affidavit in opposition filed by the respondent, filed by the Director of Higher Education. And it is submitted that at the time of appointment, at the time of appointing the writ petitioner from a prior approval from the finance within bracket SIU bracket was department was not obtained, which is prerequisite before approval is granted by the Higher Education Department. The Learned Standing Council for the Finance Department has submitted that it is the policy of the state that the first salary is released by the finance within bracket SIU, bracket was department, so that a record of lawful appointments made by the state is maintained. So it is submitted that only after the first disbursement of salaries made by the finance within bracket SIU, bracket was department, comma, will the concerned treasury release any other payment to be made to the employee.
Yes, sir.
Full stop. It is submitted that there is nothing on record to show that the finance within bracket SIU, bracket was a department of the state was apprised of such appointment or any request is pending before the said authorities for approval.
Proposal or yes,
The request on the proposal is pending, was submitted to the finance SIU department. Next para. Where is that advertisement?
Advertisement also annexer 7, page 25. This is type copy, it is in particular language 26. Type copy at page 25.
So, having regard to the submissions made by the Learned Standing Council for the Finance Department, the purpose of the constituent opinion that it would be appropriate to direct the authorities in the higher education department to take note of the requests made by the principal of the GN College Boko regarding approval of the appointment of the petitioner pursuant to advertisement. First of the Director of Higher Education, Assam, shall also take note of permission for advertisement granted by number, by letter under memo number, capital G within bracket, capital B, bracket was AC oblique permission oblique 166 oblique 2014 oblique 15 dated 28/10/2014, by which permission was granted for advertisement to fill up the post of grade 4 within bracket annexure 6 to the writ petition.
Lordship 6 is for unreserved post, for me Lordship is annexer 5.
Annexure 5. Okay.
Yes, Lordship, because there are two permission lots.
Oh, okay. Just change the letter number. It will be number capital G within bracket B, then G capital within bracket B, AC slash for capital PER permission, PER oblique 140 oblique 2011 oblique 33 dated 16/8/2022. In respect of grade 4 post reserved for OBC and MOBC, and move the competent authorities in the finance within bracket SIU department for granting an approval. Full stop. Is provided that the Director of Higher Education, Assam, shall within 21 days from the date of receipt of a certified copy of the order shall take necessary interdepartment steps to verify the appointments so made to the petitioner in respect of the petitioner, and within a week thereafter move the Finance within bracket SIU department for approval. Full stop. It is also provided that in the event any interdepartmental clarification is required, it would be appropriate that the competent authorities in the higher education department and finance within bracket SIU department and or any other department who are required to be consulted shall have a joint meeting through its nominated representatives so as to have so as to enable them to take a decision on the request made by the principal, JN College Boko, to approve the appointment of the petitioner, namely, what's your name?
Shankar Das.
SNKR Shankar Das in grade 4 post of JN College Boko, reserved for OBC, public MOBC candidate. Full stop. The issue relating to the approval of appointment of the petitioner would be decided and communicated to the petitioner, as well as the JN College Boko, within a period of 3 months from the date of receipt of certified copy of the order by the Directorate of Higher Education Assam. Okay, so within 21 days, you have your interdepartmental, the education department will do the interdepartmental exercise. Within a week thereafter, you move the finance.
Finance will consider.
Finance will consider, we have 3 months to communicate to the petitioner and to the JN College. Correct? Next paragraph. In the meanwhile, the Learned Standing Council for the Higher Education Department or Finance Department, as well as Council for the college, shall send a downloaded copy of this order to the authorities as an advance information.
After receiving the necessary proposal, the director will be directed to issue the appointment order. Because otherwise, let's say these petitions are deprived since 2018.
No, they will do it. That is what the order is. They will communicate their decision to you.
Otherwise also have been removed.
No,
from
they may,
service.
you see, they may not approve it also.
Yes,
So
ma'am.
whatever decision they take, they will communicate to you.
Lordship, the petitioner can come and challenge that order if he is agreed by it, my lordship.
No, that is okay. I'm not commenting on that. But whatever decision you take, you have to communicate. Positive, negative, we don't know.
There is a small mistake, Lordship. The date should be 16/8/2012. It has been recorded as 16/8/2022. It should be 2012 now.
Please give the date again.
16/8/2012.
15/8.
16.
16/8/2012. I made a mistake
Instead of
somewhere.
2022. Lord.
Okay, it should not be 22, it should be 12. Okay.
16.
Deployable.
Just a moment. Correction of date of birth.
Yes, Lord. On the last document, Lordship.
You were appointed in 92. You woke up in 2015.
Lordship, on last occasion, over there, records from headmaster was called for Lordship.
Yes, show me that. We can record by an affidavit. Bring it on record. Your name?
AK Azad Lakshmi. AK Azad Lakshmi.
Mr. A.K. Azad, and counsel for the petitioner, has produced a photocopy of the school records pursuant to order dated 3/5/2023. Mr. Azad, standing counsel for the Higher Education Department is present. Next, the petitioner is permitted to bring on record the said document by way of an affidavit. By when you can do it?
What's it? Date may be fixed on to say within this month on any day.
Okay, list on 31/5/2023.
Hardly based on division, my lord, because on August he is going to retire.
In August, he is retiring.
Yes, sir. So, my lord,
Okay, 26/5,
On 24 maybe, my lord,
24.
or before that, my lord, 17.
It's not possible because every matter is being adjourned for
Last-
2 weeks. 24, okay, let it be 24 then.
Most of them.
19 and 20.
My lord,
Yes, Mr. Nandi,
I'm in the item number 19.
yes.
My name has been shown on the petitioner's side.
So no
I am for
problem.
the respondent number
Yeah.
5, my lord. That I want to,
It's okay. You are for the respondent.
yeah, I am for the respondent number 5.
Okay, okay.
Your lordship,
Yes,
in the last order, 25 of 2022, 3 weeks time was given to file in.
it's okay. If you don't file an affidavit, you proceed with the hearing. You
Your
can't
lordship, my
compel
senior
anyone.
is not available right now.
Pardon me?
My senior, Mr. Ikyu Nair, is not available right now.
Okay.
He's on leg in another court.
You are paying for an adjournment.
Yes, your lordship.
Yes, Mr. Nandi, when do we fix it?
They want time, if they are not ready, it is up to the lordship.
Okay, all sides are duly represented. On the-
I am appearing for respondent 5 in item 20.
Okay. I'm not recording names right now. All sides are duly represented on the prayer made by Learned Counsel for the petitioner. The matter stands adjourned today. List on 29/5/2023.
Deeply.
21 bail hearing.
Yes,
21, no?
this for the petitioner.
Morning he has mentioned, but at that time, CD was not available with us.
He has some difficulty in second half, he said.
Yes, yes. Maybe fix on Friday,
Okay.
CD with us, madam.
Both sides are represented. on the prayer made by the council for the petitioner. List on 12/5/2023.
24 for orders.
Please, your lords.
Yes,
Lordship, as for the earlier order, we have taken step upon respondent number 4. The newly completed content. And Lordship, as per the records, it has been received also. The notice.
very good. Who's for the elementary education? Elementary. None appears on call for the. Sorry. We'll issue a direction to the elementary education officer Morigaon to be personally present. You see, this is what they are doing.
This matter, it's gonna be in a list, it's not shown, madam.
No, it will not be shown because this is a contempt matter. But look what your officer is doing. He's inviting problems. Like this. Your departmental officer are becoming wiser. Look what they are doing. They have,
If it's a contempt matter, my lord,
I
the
understand.
concerned councils have to be appearing, you know, I'm actually not the authorized council, madam.
I understand, but look at, I'm just showing how your, how wise your officers have
Oh,
become.
yes, lordship, directly they've written, my lord. That is a, my lord, similarly, my lord, it happened once, my lord, in another matter. We had, I'll take it up with the authorities, my lord, if this is the case, my lord, it happened in, you know, 23 only.
So we'll
We'll-
ask him to be personally present.
My lord, just give us a,
No, it's okay. Otherwise, they'll not understand.
my name will be reflected.
No, it will not be reflected. I'm just showing it to you. You can report to your authorities.
I'll
You're
inform, my
not,
lord.
you're not the council on record.
My
So
lord,
your name will not come. Definitely your name will not come.
I'll inform, my lord.
If the department officers have become wiser, it has to be. Your department has to know that they have become wiser.
They cannot write directly to the councils.
I know, that's why I said they have become wiser.
Lordship, this is the third time we are.
No, now we'll call that, just send it back. You may not be entitled to any relief
My lord.
because they have produced document to show that your candidature by the DLC was rejected.
Yes.
So you may not get the desired relief, but still in the manner which it is done, we'll call for the personal appearance. When counsel to the petitioner is present, the office note indicates that the district elementary education officer Morigaon was implicated as respondent number 4 on receipt of a show cause notice in connection with this contempt petition has sent a show cause reply directly to the court. Which consists of a parawise comments, as well as the minutes of district level committee meeting held on 12/5/2013, whereby the candidature of the petitioner was rejected. Due to non-fulfillment of required percentage of marks. Full stop. As the said focused reply is not supported by any affidavit, or the court is unable to take cognizance of the focused reply filed. Therefore, comma, the registry shall issue a notice to the district elementary education officer, comma, Morigaon, namely Mrs. Buli, Buli, Gogoi Bhuiyan, comma, AES, to be personally present before the court at 10:30 AM on 2/6/2023. So the said notice shall also contain a statement that in case the district elementary officer is not present in spite of receiving notice, comma, the court may take coercive steps to compel her appearance. To compel her appearance. Next, this order we brought to the notice of EOJ contempt section. Based on 2/6/2023. Just before that, you write, in the meantime, the note shall be put up as to whether notice issued to the newly implemented respondent of who has been served or not. Just about that. 26. Yes,
Eighth is your lordship. Lordship, order has been complied with. Madam.
complied with. Your name
B.D. Sharma.
upon instructions.
SMT 60 is there. SMT 60 is there, my lord.
Upon instructions, Mrs. B.D. Sharma, learned counsel for the petitioner, submits that the order of the court has been complied with. And therefore, she has instructions not to press the matter. Mr. SMT Chisti, when it's standing counsel for the Secondary Education Department, is present. When he is present for whom? Mr. Chisti is for?
Yeah, my lord, this is not respect judgment.
Okay, he's present. Okay. Okay.
Master level.
27.
You're in 27?
Yes. Yeah.
How's the health of Dr. Dr. Ahmed? How is he now?
Oh, not so well, Your Honor.
Still not well.
Not so well. Yeah.
Okay.
Sometimes he sit in his chamber. Sometimes sit in the chamber, but not regularly.
Okay.
Yes.
He is in Guwahati.
Yes, is got it.
Okay. What is the problem now he's having?
Some nerve problem and brain stroke.
I'm so sorry, he's a quite an amicable person, but
Yes, yeah.
he can speak over phone.
Pardon?
He can speak over phone.
Yes, you can speak in over one, yes.
Okay, just write his phone number and give it to the court master. Let me call him sometime.
Okay, yes, yeah.
Yes,
Yeah, here in this case, matter relates to the selection of the principal of
yes,
Koilapur as an rescue,
but is it still live? What you
records-
call the selection process of interviews 2017.
Yes, on the
You
last,
said the select list is not published. Yes,
not published, last occasion, this honorable court has called for the records of the selection, on 2012-2018. 2012-2018, but still not received.
you see, the difficulty is elsewhere. Although we can call for the records and examine it, but in 2017, you were 48 years. Now we're in 2013, 6 years. The age of employment is already gone. And you see, the second problem is just show me where is the advertisement was. I forgot. Where is the advertisement?
Advertisement, page number. Okay. 24, Your Honor.
24.
Yes,
Now, in this,
there is,
no, I think from this, the qualifications given in the advertisement,
yes, Your Honor.
that has perhaps been altered in view of the changed circumstances.
That the petitioner, he is qualified and he was ranked first, stood first in the,
No, at that time I understand,
yes, Your Honor.
but under the present, what you call parameters,
Yes, Your Honor.
the present requirement of law,
Yes.
is he still qualified?
Yes, Your Honor, still he is qualified here. Present qualified.
This post of principal,
Principal, Your Honor.
he is required to have that net slate and the other qualifications.
Yes,
Does he have that?
yes, he has already, he has, the qualified which is required, he has already submitted.
No,
this-
what was required and what is required are two different things. I am asking a question which is in present. The present requirement of of holding a teaching post,
Yes, Your Honor.
is he still qualified? That is what I am asking.
Yes, he is qualified. My lordship.
Okay. Yes, Mr. Sharma.
I have not yet received my instruction.
No, they will not give. Nobody is interested for the petitioner. He's an ordinary citizen. He has to come to court and litigate. Nobody is interested. He's a common man. Remember Akil Ashman? Common man. And in election, the judgments of the Supreme Court says little man. In litigation, in what you call this election cases, Supreme Court uses a different term. It uses the term little man. So we'll ask your officers to be here with the records.
Yes.
we'll give them 10 days time. They'll appear.
Records.
This along with the records. The matter has to be resolved. Because the petitioner says that he is still qualified. Learned counsel for the petitioner. And Mr. U. Sharma, learned counsel for the Secondary Education Department representing respondent numbers 1 to 4 are present. This writ petition was filed on 12/12/2017. And notice of motion. And after granting several granting time to the respondents to on several occasions to provide information or the matter was disposed of by judgment and order dated 7/3/2018. Stop. On a what is it? So thereafter, by virtue of order dated 26/11/2018, passed in review petition 63 of 2018, the order dated 7/3/2018 was recalled. And the writ petition was to be heard on its own merit. No, we can't be so harsh with them. The notice of motion was never issued. Nobody pointed out before the court. Notice of- No. There is no order of issuing notice of motion. All throughout, time was granted to the authorities. Because it is only my bad habit that I read the orders. I found out that there is no notice of motion issued. Otherwise, I would have done a blunder without issuing a notice. I can't dispose of a writ petition. It's just don't write so many things then.
Well, it is common on order column. It is come in this repetition is common on order column.
That is what I am saying. You see, nobody pointed out this matter is pending till 2007. For 6 years, nobody pointed out that notice of motion was not issued. Without notice of motion, I can't do anything.
Yes.
It is painfully observed that although this repetition was filed on 12/12/2017, and the matter has been listed on many occasions since 16/12/2017, or the Learned Counsel for the petitioner never pointed out before the court that notice of motion was not issued. Although the writ petition was disposed of by order dated 7/3/2018, which was recalled by order dated 26/11/2018 in review petition 63 of 2018. Stop. It is noted that several orders were passed requiring the secondary education department to produce the records of selection of principal of Nehru Higher Secondary School, Poilipal, POILAPAL in Kasha district. But the orders of the court have not been complied with. Next paragraph. Let a notice of motion returnable on a fixed date answers will be issued without requiring the petitioner to take fresh steps. Nonetheless, extra copy of the writ petition we served on the learned to Mr. U. Sharma and standing counsel for the secondary education department in course of the day. Next paragraph. It is noted that orders were passed on several occasions to enable the secondary education department to provide appropriate instructions to their standing counsel, as well as to produce the records. It is made clear that in the event the affidavit in opposition is not filed by the respondent numbers 1 to 4 on the at least 2 days prior to the returnable date, the Commissioner and Secretary to the Government of Assam, education within bracket secondary bracket close department. This is number 1. Number 2, the Director of Secondary Education Assam within bracket. This is number 2. Number 3, the Inspector of Schools Kasha District, Kasha District Circle. Number 3, shall the person personally present with the records of selection of the.
Well, a copy has not been served to us, minor extra copies. So
You see, for 6 years, you did not ask them. Today, I am ordering them to give you a copy. Is it permissible to you? After 5 years, you come and say that copy has not been served. You should obtain a certified copy if you don't want, if your authorities want it. But now I'm issuing a direction that within 2 days prior to the next date, either they file their affidavit or be present with all the records. And unless I direct you as commissioner, your offices down below will not be working. Once an order goes to a commissioner and to a director for personal appearance, I can give you a certificate that they will give you instructions within 24 hours of receipt of their notice. You take the downloaded copy today, transmit it in the night, dead of the night. Within 24 hours, you will get a reply that you are getting instructions. Because Mr. Sharma, I don't know whether you were there or not, but in earlier times in the court proceedings, I have seen officers coming to court within 2 o'clock, ready with the instructions, ready to file an affidavit at the call and beckon of the court. Those days we have seen. You want me to repeat that? I'll fix a date on Friday, and I'll ensure in my orders that your officers will come. You want to see it? No, okay. With the records and so on, full stop. If required, the said authorities shall seize the record of selection from the college concerned. Full stop. In the event the records cannot be produced by the school authorities, the authorities in the education department would be well advised to take appropriate steps to ensure that the records are restored and produced before the court. Full stop. Next para. List on so and so. 16:6. By which time the either an affidavit should be filed or the authorities should be personally present with the records. Next para, the learned Standing Council for the Secondary Education Department shall send a downloaded copy of the order to the authorities to bring it to their notice. But today, in course of day, you give them copy.
Yes, yeah. Yes, I will forward.
If they don't give you after 2 days, make a mention, we'll recall this order. You make a mention before this court, we'll recall this order. Within course of the day.
Today itself, I
Huh?
will give you
Otherwise, on Friday, I'll recall it.
most of it.
Yes, item 29. This should be 28, I think, just some mistake. 28. Ah. Yes, 28.
Madam, my affidavit was ready. I could not file it 2 days time, madam. I filed it by Friday.
It's a contempt proceeding.
Madam, it's the order has been complied with, but my letter friend wants it to be brought on record by an affidavit, madam. There was
It's been complied
an
with.
error submission.
Okay,
We'll do it by
Then give
Friday,
time.
madam.
Okay. Okay. List on 15/5/2023, by which time affidavit is directed by order dated 28/3/2023 to be filed. Ms. B. Vinay, Senior Counsel for the petitioner, as well as Mr. R. Muzumdar, Learned Counsel for the respondents are present. Yes.
29.
Yes,
Last order, my lord. The respondent side was directed to take the instruction. my lord.
Already complied with me.
complied with, okay. So what is it? Just tell us.
Yes, my lord.
What is it?
As per this order, my lord, the claim for the issue earlier, these complaints are stemmed that cancel the claim of the both schools are rejected, my lord, as they have not dies the amount.
Pass it on, then you let the pass it on. Please send. No, but if the claim of both the cases, both the schools are rejected,
Yes, ma'am.
you see, one of the two schools has to be a genuine school. How can the claim of both be rejected? So,
My lord, as per their inspection report, my lord.
The petitioner's school, my lords. The petitioner's school was established way back in the 1990.
just a minute.
This is also.
Actually, these are, Ms. Fukan, this may not be a appropriate ground. You think about the scenario. You think you are the person aggrieved, correct?
Right.
The court issues a direction that some inquiry is to be made. You think of any example, you are in that situation,
Right.
the court directs that an inspection be carried out. On that day, maybe because you are unwell or some family members are unwell, you have to attend them. You are absent. I, as an inquiry officer, should I say that I went to Mrs. Fukan, Ms. Fukan was not found, and therefore the claim is rejected? How would you like it?
That's true.
You don't even give the time. I know that you will be, I will rise at 4:15. So before last matter, you will be walking out because Mr. Mazumdar will be doing that matter. So 4:10, you leave the court. And then I jump to next item. And then say Ms. Fukan is absent, dismiss for default. How do you like it? Time is not given. When did he go was not given. Explanation whether he was absent with prior intimation. You see, I may take a leave. Tomorrow I have some work, I'll have to take a leave. I inform my authorities in the registry that I'll be taking a leave. So can somebody come and walk into the courtroom and say that, oh, Justice Surana is not there? Dereliction of duty. Can that happen? This is not tenable. You see,
Well, as per you,
you see, I'm just trying to understand this. I'm asking you questions only to understand. The decision is during physical inspection by field level officers, DEEO Barpeta, DIS Barpeta, BEEO Bhavanipur. It is found that both the schools have the same DIS code, which reflects the occurrence of some irregularities. See, both of them have a DIS code. In the prior page, you say, as reported, both the said schools have their own plot of land having same DIS code, but could not produce necessary documents, records, for example,
yes, ma'am.
admission register. Can you reject? If you ask today whether the supporting staff in the courtroom, their attendance register is available or not, I don't even know whether it is maintained. The attendance register of my court staff. I am the in charge here, and I really don't know where the attendance registers are signed by this staff. So just because I can't show my register, can anybody be penalized here? Attendance register doesn't show you take action against them. I don't know. This is something I can't. Ms. Fugan, you have read this. You have read this, I believe.
Yes, ma'am.
I find even if I consume this with a pack of Hajmola, I won't be able to digest it. So what do we do? Rejection of vote is not permissible.
Otherwise, they can go for another petition.
No, that will be never ending.
Selling-
What
selling
is your
disorder
protocol?
manner.
What
At
is
that
the
time
inspection
only-
protocol?
Manner.
What is your inspection protocol? This, you see, this is a school established in 1990. Correct. Recognition was given on 1/1/2005. If that be so, that means your officers who gave approval for recognition, They did their homework in their own home. No field inspection.
As per this, they have done.
Yes.
Please.
But the process in which it is done, what I am told is, the,
No, let me understand in a different way. When you ask time, let me change my question.
madam,
You see, number one, this generation of DIAS code is an automatic process without requiring approval of any authorities of the education department.
the CRCC, what they call the CRCC, Cluster Resource Coordinators, they issue the forms every year. All the schools which are interested in having their DIAS code numbers have to take the forms, apply. Once the application is made, the DIAS code number is generated.
That is automatic,
Now,
without inspection.
that inspection part, because the CRCC and the other persons involved are usually the block elementary education officers, the DO, so on and so forth. So once they know which schools are existing, documents are supplied along with the application forms. So that is how the DIAS code in each year is generated. Now, the registration for the recognition for the year 1/1/2005, it was given on an application made then. Thereafter, if the school is functioning not as a provincialized or a government school, if it's a venture school or it's a private school, to obtain the DIAS code, it is the duty of the schools to ensure that their applications are submitted on time and the DIAS codes are accordingly
Let us
generated.
pause here for a moment. Now, you see, you take a glimpse of that report.
I have.
You have that?
Yes,
In the first page, last paragraph,
my lord.
it says so and so jointly visited and submitted inquiry report on so and so. As reported, both the said schools have their own plots of land having the same DIAS code on 2/9 DIAS code so and so. Correct.
Yes.
Now, the last entry which was made in your record, you could have verified that who uploaded this, because you, so far as I understand from the statements made at the bar, a DIAS code once generated and accepted and catched,
Yes.
it can't be manipulated.
Changed. It cannot be changed.
So therefore, last 2 or 3 years, who has filled up the DIAS code is a document which is available with you.
Here, since the issue was one of provincialization, the DIAS code or the requirements to be fulfilled was of under the 2011 Act. So it was at that point of time we have to verify. But just prior to that sentence, where Lordship had, if I may read the sentence just prior to that. Further, in compliance of Honorable High Court's order dated 9/6/16 passed in 6/8/05/15, a hearing was conducted by the Commissioner and Secretary, Elementary Education Department on dated 3/5/19, giving opportunity to both the parties, that is the petitioner and the respondents, for arguments. Hearing both the parties, Commissioner and Secretary asked DEO Borpeta to inquire the matter at the field level and to furnish a detailed report so as to issue a valid reasoned order. Accordingly, DEO Borpeta, DI of Schools Borpeta and BO Bhavanipur jointly visited Kumalipara MEM. Now, this Kumalipara MEM is a venture school. Venture schools, my lord, what my understanding, they function from 2-3 rooms. They do not have a building or a big the infrastructure. So when the visit is made, calling for the records or production of records, if not kept with the president or of the SMC or not kept somewhere else, it is always available in the school.
No,
So, my lord,
you see, now you come back to what you have read.
my lord,
It says an opportunity of hearing was granted.
yes,
Both sides were heard.
yes.
So at the time of hearing, it did not occur to you to have this records produced.
My lord, they must have produced whatever records were with them.
Correct.
Both
So
must have
the
given the same
authorities-
dash number.
So the authorities would write here for an explanatory note
Yes,
that X for this school produced attendance register,
yes.
the original could not be verified at field.
In case they do not
You
come,
see, what documents are there? You just think of yourself to be the counsel for the petitioner.
my lord.
I always give that example here. Now the government advocate produces a record. You are the counsel of the petitioner, you don't know anything what is in the record. And I dismiss your writ petition based on the record. How would you feel it? So therefore,
Lordship will give us a week's time.
so
I'll
therefore you
call for
see,
the records.
when you have that hearing done, only those you can have a verification done. Because if in the verification mode, you require 10 more documents. You may have it, you may not have it. Because that is the principle being followed, even in an income tax raid. In income tax, you give a return. The supporting documents for that, there's a what you call scrutiny. They are required to give you a notice requiring what documents you have to be produced. It's a principle of natural justice. In a GST also same thing. So
One aspect would be there, my lord. This is a contempt petition. Now we were required to pass an order. If lordship feels that this order is either in violation or there's something.
Then he has to
deliberate,
challenge
then that is another issue. Otherwise, if there's something wrong in this order, it would be upon him to challenge it. And in case it so falls from your lordship, I am ready to go through the records that were referred to in this while passing this order, put it in a form of an affidavit, that these were the records, this is what we have done, and this is the order passed. We may be correct or we may be wrong, but this is the order passed. Till that, my lord, I can bring it on record to assist him so that he knows what were the records produced and what were how the judgment, how the decision was arrived at. That will perhaps assist him in filing a fresh writ petition.
for that he'll
That I can do within a week, my lord. That will not take much time, because
Mr.
once the order is passed,
Mr.
I just need to
Islam
have
is-
the records.
Mr. Islam is capable of handling that situation.
My lord.
I am only concerned, you see, because of the fact that
In case
this-
somewhere there is an opinion of this honorable court that this may not be complete compliance, so that we have not acted rightly in coming to this conclusion. My lord,
No,
we'll
that
give
is
an
correctness,
opportunity just to-
that is correctness of the order, it can't be
No,
adjusted.
not the correction, the procedure even followed. If lordship finds that no, you did not look in, the authority should have looked into this or that. Lordship will allow me one opportunity to bring on record that this was the process we followed, and this is the order we have passed. Because, my lord, we do not know what happened in that hearing on that day. That will be only reflected in the file notice, which is not with me as of now. Or whether the DO had given them a prior notice to be present in the school on so and so date to where they would go for inspection. That part, my lord, I can only bring on from records. Perhaps the authorities have understood that production of a order would be sufficient to answer the contempt petition. Otherwise, I can come up with an affidavit, my lord, bringing on everything on record. If it has been done perfunctorily, even that would be contempt. I admit,
No,
and therefore I would like to see,
we have another way to tackle it.
my lord.
You see, the easy way to tackle it is that you come to the order of the court.
Yes.
Recent order is to be passed on or before 31/8/2016.
Yes.
That having not been passed,
my lord, yes.
you see that the show cause notice,
That-
what you call, this has not been complied with, so these people will be personally present.
For the.
I won't say on
For the
record,
delay, my lord, at best, they would be, they can, my lord, tender their.
there's no explanation, no affidavits have been filed.
No affidavit isn't filed because what was, my lord, perhaps their understanding is that once the order is complied.
But this is something you can communicate, we'll just issue a notice,
My lord.
since no affidavit has been filed. They'll explain their conduct. What has transpired within the court will be your communication, privileged communication between you and your client.
My lord, I get to go through these orders, or I come to know about this only because, my lord, it comes up in the group.
I
So
understand,
it's-
I understand.
I-
No, means
There-
you means he,
Well,
you take the benefit of what you call General Clauses Act, he would include she. So have that communication made, privileged communication between you and between her and the clients. In the meantime, I'm issue a notice. Let them have some explanation. After 2 years, if they do it perfectly,
Yes, from 16 to 19, how the 16 to 22, to 2020.
2020.
What transpired in the department, whether there was some deliberate delay or not, that, my lord, that we will try to explain from the records.
Mr. S. Islam, let me counsel for the petitioner. And Ms. N. Fukan, let me counsel appearing for the respondents. the respondent. Next one. The learned counsel for the respondent has produced a copy of order number capital ELC. You just give a copy to him also with a copy of order dated 30 January 2020 passed by the respondent, by which the claim of both the schools, i.e. Komuliapara, KUMULLIPARA, MEM, headed by Laili Khatun, LAILY Khatun, KHATUN, and Komodia, same name, Komuliapara, MEM, headed by Iman Ali Ahmed, IMAN Ali Ahmed, were rejected. To stop. Let a copy of this order be provided to the learned counsel for the petitioner. Next para. It is noted that this court by the order dated 9/6/2016 passed in WPC 6805 of 2015 had directed the respondent to pass a reasoned order on or before 31/8/2016. The respondent has not filed any affidavit of show cause as to why the order of the court was not complied with.
2018.
Next comma. Next comma. Moreover, comma, it is noted that the personal appearance of the respondent has not been not been dispensed with. Therefore, comma, the respondent is directed to
Becomes it.
appear
Becomes it.
at 10:30 AM on give 4 weeks time, give a date.
14/6.
By which time an affidavit shall be filed to show cause. Next para. The learned counsel for the respondent has submitted that the respondent is no longer the incumbent in office as Commissioner Secretary to the Government of Assam, Elementary Education Department. So this said statement is noted. Next para, list on so and so. The learned counsel for the petitioner has been downloaded a copy of this order to the respondent to bring it to his notice. Next para, the copy of order dated 30 January 2020 is kept as a part of it.
If the person is retired, madam, in case an affidavit is filed, could the personal appearance after consideration of the,
No,
after consideration of the.
Make a clear there for exemption.
My-
You know the procedure. Because I want to send a message that
Yes, yes.
contents are not to be treated in English, because otherwise this orders of the court not complied with.
We'll file an application for exemption.
And so far as Mr. Islam, you are concerned, this notice has been issued. But on the next date, we are likely to close this matter. 2018 matter, you'll have to challenge. The,
Order is very clear, my lord. It is 24 minutes.
no, I've seen that, but it is rejected.
lord.
Once it is rejected, you know what to do.
Litigation, my lord. This is
No, you know what to do, otherwise you know what will happen.
Yes.
The delay will cost you. You do whatever you want. We have given you a copy, that's why.
Yes, but the respondent was specifically directed to comply with the order that pass a recent order on the basis of the reports dated 27/2/2019.
No, you see, that is between,
Yes.
that is between the court and the respondent.
Yes.
But what you have to do with that order is your concern.
Yes.
Correct. You think over what you want to do.
First one, next week.
Those, Mr. Mazumdar, in contempt petitions, I have not, because this is the requirement of the law that personally appearance will be there, but you make a prayer for exemption. You consider that. Yes, next item, 31.
Yeah, please, I beg apology, when item number 21 was called, my lord, hearing meter, my lord, I was on leave in another court, my lord, I have asked.
Which item?
Item 21, my lord, bail hearing meter, my lord.
Okay, we'll take it up. System. Let me finish this matters. Contempt matters, we'll take it up. Yes, this is,
Lordship, in this case, the respondent has appeared, their name has also been shown. Let the matter come up for admission, Lordship. next
respondent
week.
of 5, he has appeared.
31 lots, 7 and 8 is appeared. They are
No,
the
no.
ma-
Here the office note is that you failed to take steps on respondent number 5 despite directions by the Lavazima court.
Lordship, 7 is appearing, he's the headmaster, he can take care of Lordship.
No, that I don't know.
Or your Lordship, I can take fresh steps,
Respondent number 5 will have to take first steps. School managing committee,
Lordship.
who's appearing for respondent number, this headmaster?
7 and 8 are the same person, A.M. Barmia. His name has been shown.
A.M. Bhavia. Can you bring him?
Lordship,
Can you bring him?
I don't know his number, Lordship.
You see, A.M. Bhavia, item number 31. Just wait for some time if he can appear.
Thirty-two.
Yes,
My lord, my instruction is not complete, my lord. Matter relates to comprehended appointment, my lord.
yes.
My lord, as per initially, my lord, the case of the petitioner was considered in the TLC meeting held on 2017, my lord, where it was considered but could not be recommended due to lack of vacancy, my lord. There was no vacancy. Again, it was placed in the TLC meeting held on 12/9/22.
No, that may not be correct because the petitioner's case is that the post for which he had applied, his mother had died and that post is still not filled up. So that means vacancy exists.
My lord. Now, as per minus 12/9/2022, my lord, the DLC minus says, my lord, the vacancy status of grade 4 submitted by the principal so and so college. Notice that one grade 4 vacancies is still available, my lord. So it has been forwarded to the SLC, my lord. Now, what happened in the SLC, my lord? To that effect, my lord, I am awaiting instructions,
Okay.
my lord.
None appears on call for the petitioner. So Mr. G. Pegul and government advocate has submitted that as per instructions received by him, there existed vacancy in the concerned Manavendra Sharma Girls College, Rangia. And therefore, the DLC meeting is when? Therefore,
12/9/2022.
therefore, in the DLC meeting held on 12/9/2022, the name of the petitioner was recommended. So he has submitted, it is submitted that he has not been instructed whether the matter has been taken up by the SLC and the outcome of decision, if any. So accordingly, matter stands adjourned today to enable the learned government advocate to obtain updated instructions.
My lord.
2 weeks,
2 weeks.
we'll start 2 weeks.
Thirty-three.
Lordship, I have prepared IA for substitution and need to be signed by the parties. So I need 1 week time.
Okay. On the prayer made by Learned Counsel for the petitioner, the matter stands adjourned to enable him to file an impleading application. List along with the said application if so filed.
34.
Yes, Mr. Kumar.
Well, there was a direction to pay the basic scale of pay. On the last occasion, an instruction has been put on record saying that they are going to, as per the cabinet decision, they are going to pay fixed pay. So there is a lot of difference between the what basic scale of pay referred at page 28 and the fixed pay which the cabinet meeting took on 4th of November 2022. Page 28, my lord, paragraph number 22. And this order was.
Mr. Gogoi,
Lordship, Lordship,
you see, come to page 28.
Lordship, Lordship.
Para 23 says, in view of the above reasons, the respondents are directed to pay to the petitioners the
Lordship,
basic scale of pay,
Lordship.
including areas of so and so.
Lordship,
Correct.
Lordship,
So the respondent authorities,
Lordship.
they have accepted this order.
Lordship.
Uh,
And it was
anything-
given lordship. The basic scale is lordship. 55,000, it starts from 55,000.
It's a basic scale. It's not a
Yes.
fixed pay.
No lordship. So lordship, that was given. Earlier it was lordship
no, no.
21,600.
No, because you see,
Lordship,
on the last occasion we had recorded. If it is wrong, I don't know.
lordship,
Order date 27/3/2023, I have
Yes.
recorded
lordship.
that the higher education department, on approval of the cabinet meeting held on 19/10/2022,
Lordship,
the higher education department has enhanced the fixed pay of the petitioner to rupees 55,000.
lordship.
So therefore, this, and then we say that by another order dated 15/10/2019,
Lordship,
in compliance with the order of this court, the higher education department had
And-
approved another 3 years beyond 2 years to the petitioner for acquiring net
lordship,
slate.
lordship,
Correct. So
lordship.
therefore, it is not a basic pay scale.
Yes.
It's a enhanced fixed pay.
Lordship, kindly pays 15, enhanced fixed pay, 55,000 is the basic pay, lordship. This is the basic UGC pay scale, lordship.
Where page,
Lordship, even lordship, annexer, I have
Page,
given
page.
that 15/10/2019 letter, lordship, I have given, lordship. Just I have read out, lordship. Department was please approve 3 years beyond the 2 years for acquiring net and sale of the petitioner and pay basic scale of pay, including areas with effect from 22/1/2015 and
Okay.
fixed pay already given to the petitioner would be adjusted to the basic scale of pay, lordship. Lordship, 55,000 is the starting basic scale of pay at present, lordship. When petitioner
you
claim,
are-
lordship,
you are trying to say that since the net slate has not been achieved,
lordship, lordship.
he is still getting the pay at basic pay only.
Lordship, lordship. That is the 55,000. Even lordship, when petitioner is claiming lordship, it was in 21,000 lordship. Now it was lordship enhanced to 55,000 lordship. Earlier it was 21,600 lordship.
Just a moment, but is this what is being said?
Your lordship will see the communication which was placed on record on last day, that is of 4th of November.
No,
2022.
Mr. Kumar, so what I'm trying to do is that I'm reading the order of this court. And then I'm trying to analyze what they are doing. It says, because here it says, you see, para 22 of this order of the court. The present is the petitioners have been regularized against the sanctioned vacant post as per so and so. The persons were appointed as assistant professors in similar places, though appointed in the 2011 Act. Petitioner's appointment under orders so and so are given basic skill pay prior to so and so. The petitioners cannot be denied payment of basic scale of pay.
Yes, ma'am.
Correct.
Yes, ma'am.
Now, this basic scale of pay, if you don't acquire this net slate for which time is given, there's a policy decision of the state that you will not get an increment. So where do you stand?
My
Well,
lord, kindly peruse
just a
paragraph
moment.
21 lordship.
This time,
My lord, there are three parts to the order. Your lordship will look at page 26.
Yes,
Page 26, Mala, just above. Accordingly, in the interest of justice and equity, these courts direct that the state respondent to grant the petitioners herein another 3 years beyond the 2 years period given under condition number 3 of the order dated for acquiring net slip.
yes,
Then consequently, insofar as OM dated 17/7/2004 and condition number 3 of the order dated so and so does not provide for a period beyond 2 years for acquiring net slip, a corrigendum or new notification should be issued by the state respondent extending the time period of 2 years given for acquiring net slip to 5 years. This corrigendum was also not issued by the state government, extending the period. And if your lordship again go to that paragraph which your lordship has read, it is clear that this honorable court that persons who did not have the net slip were given the basic scale of pay prior to the acquiring of that qualification. And in the paragraph number 23, it has also been specifically stated that the basic scale of pay, including the areas of 22/1/2000 within a period of 3 months from the day. If we look into the instruction which was placed on record of the 4th of November 2022, it says in approval of the cabinet meeting held on 19/10/2022, Government of Assam in Higher Education Department is placed to enhance the pay to rupees 55,000 fixed only in respect of 135 numbers of assistant professor annexure 1 of different provincialized colleges of Assam who are working in minimum pay fix as mentioned below with immediate effect. So here, my lord, this order of the honorable court has not been complied in the letter and spirit in which it was passed as far back as on 9/11/2018. In the meantime, my lord, two of the persons, if it was 5 years older, two of the persons who did not acquire the net slip, they have retired. So they will only get the benefit of that basic scale of pay plus even if they don't have the qualification. So far, this is concerned, my lord, net is a different area, my lord, to which they have to satisfy that they don't have issued a corrigendum. But the court never said that it is fixed, my lord. It is the basic scale of pay. So they are giving it only fixed pay. Fixed pay, your lordship will know that.
no, if it is a basic, you see, if you look at the revision of pay rules,
Yes, my lord.
the basic pay will be available there.
Yes, but the your basic pay scale of pay means now we don't have the scale of pay. It's now only grade pay and there's pay band and all those concepts are there. Now we don't have this concept of scale of pay. Scale of pay was in the earlier prior to 2010. Now we
Mr.
have the
Kumar,
pay
let me-
band
let
and
me
all
tell
those
you,
concepts.
Let me tell you, in these days, I've seen many, I've handled many matters where similar issues have come up. There are directions not only from the state government, but there are orders even from the education department, central education, the authorities, including UGC, saying that once they don't have the net slate, they will not have the entitlement to pay increment. Correct. So there are two ways of looking at it. Number one, order of the court. We know our handicap because this is a contempt jurisdiction.
We cannot go behind the order.
Beyond the order. But there's another concept which is called non-compliable order. Correct. Executing court will have the authority to go into it. Now, I am not on that also. But the fact is that if there is a standing order that the pay increments will not be available, technically those that will have to be challenged by you again.
So this is not their contentions of pleadings. They want to say that this fixed pay is the basic scale of pay which we are giving to it.
Yes.
If lordship.
It is not the contentions
No,
of the
that we can
petitioner.
always
Just
direct them to
if
file an
lordship-
affidavit.
if lordship, I can point out lordship. Basic scale of pay start from you see at present lordship 37,300 to lordship 57,000. If we give them lordship, then it will reduce to 37,000 lordship. It start from 37,300 to lordship 57,000.
Well, let them put it in the form of an
Lordship.
affidavit so
After
that I
that
can
lordship, the grade pay,
response to their pleadings. Well,
grade pay
orally
and
it
other
will be
things will be
difficult for me
included,
to
lordship.
have a understanding of what they want to say by
No, because I
basic scale of-
understand,
yes.
his stand is consistent. All throughout in these days when I'm taking up this bench, his stand is very consistent. Therefore, it is what you call predictable. what he's trying to say. But have it in
Lordship,
affidavit.
Lordship. When Lordship, he is getting more than the basic pay. Basic pay starts from 37,500 Lordship.
Okay, I
Lordship.
understand your contention.
Lordship, Lordship, I will place
Have
it.
it,
I will place it, I
affidavit.
will place it, Lordship, I will place it.
Both sides are duly represented. In view of the stand taken by the respondents, it would be appropriate to direct the respondents to file an affidavit if they do not record their stand. Stop. The affidavit shall be filed prior to 2 days prior to the next date of listing. List on, give a date, when,
Lordship, after 2 weeks, any date, Lordship.
give a date, you have a time again. Take a date.
Lordship, last part of May or first part of June, any day.
30th of May.
Lordship. I will do, Lordship, I will do.
31st, not 30.
Lordship,
30 is a hearing day.
Lordship,
31st, I'm not, 31st and first week I will not be able to.
29 then,
Yes, ma'am.
Lordship, I will do.
Yes.
okay, the bill I'll take up now.
Oblige, Lordship.
21.
Biplab Respect.
Mr. Parasha is there, just find out, he will be outside,
He's there on the.
just find out. Just find out, we'll take it up. This is item
Yes.
35.
Lordship, in this case, my lord, petitioner has already retired, Lordship. So he has instructed me to close, which is to submit a prayer report to close the content case, my lord. He has already retired, my lord, prior to consideration of his.
Okay. You want us to close it or you want some time?
Let's close, he instructed me to close, my lord.
Okay. Mr.
Ace Rahman, Lordship.
H. Rahman, the counsel for the petitioner is present. Mr. J. Abidin, the counsel for the respondent, has submitted that as per his instructions, the respondent as well as the petitioner have both superannuated. Petitioner also superannuated.
Subordinated, my lord. Petitioner subordinated, my lord.
No, respondent is also.
Respondent from his post already superannuated.
He's superannuated.
Yes, yes.
He's superannuated. Full stop. Therefore, having regard to the where is that order? I took this output order. Where is that?
My lord, operative portion in page number 19, Lordship.
19.
Yes, Lordship. Starts from, my lord, page number 18.
That is annexure 8, page 18.
Accordingly, it appears that as the direction of this court by order dated 11/3/2019, asked in WBC 6458 of 2018, was to consider the case of the petitioner for promotion along with other eligible candidates. On superannuation of the petitioner, the said order would not be implementable. First of all, under such circumstances, the court is inclined to close this contempt petition. As the issue involved has been rendered infructuous. No, but Mr. Abidin, but still, if he's entitled to that, what you call, if he's entitled to be considered in the DPC, even post-retirement, it can be done still. It can still be done. Because the DPC is on the basis of the annual vacancies that appear, right? We'll issue that direction to the authorities if he gets any benefit out of it,
That can be given, a rider can be given, my lord, along with this.
next paragraph, the closure of this contempt petition cannot be construed as a bar for the competent authorities to consider the entitlement of the petitioner for promotion.
No, the benefit of the promotion.
No, first he
Yes,
is the
promo-
entitled to,
yes.
he'll be entitled to promotion, and if the vacancies for which promotion is claimed exist prior to his superannuation, or the respondent authority, the concerned authorities in the elementary education department may still consider notional benefit, if notional benefit of promotion can be granted to the petitioner, if he is found entitled to. Correct? Mr.
Yes, madam.
Avidin?
Yes, ma'am.
For this purpose, the petitioner is permitted to produce a certified copy of this order to the competent authorities in the elementary education department. To stop this observation of the court shall not be construed as a direction of the court. Otherwise, again, contempt.
No, my lord, if your lordship, again, I understand what your lordship wanted. Because, but if it is not a direction of the court is written,
I shall examine.
but I think the earlier part, it was just a consideration order, in fact, what my lord has said, if he is entitled. So question of directly, there is no mandamus, so that part may not be last part, otherwise it will be,
Okay.
they will not
The
touch.
last two, right? Okay. Okay,
Deeply agree.
still be examined. Okay. Yes, bill matter.
May I please, your lordship? See, the FIR is at page 9.
You are the transporter,
I am the transporter, lordship.
but you are said to be the kingpin. This name Viswas. It triggers my memory. You are said to be the kingpin. And what we found on the last occasion is that mismatch.
Mismatch.
What do you have to say on that?
But as per the, my lord, forwarding of the, my lord, Syamal Viswas, they have said the cows were found for the different places.
You see, there are two things which has come up.
Lordship,
If I remember it correctly, number one,
lordship,
this page 21,
lordship.
against that, what we would understand is that although there are press meetings and all called,
Lordship,
but you could not be apprehended, number one. Number two is that that if there is a mismatch
lordship.
with regard to the cows being transported, the transaction itself becomes illegal. So why an anticipatory bail?
My lord,
Do you have the, can you match those, what you call, cattle? Even now at, in this bail application stage,
lordship.
can you demonstrate that
My lord,
there is no
thousands of
mismatch?
Kettles are there, my lord. Kettles are there, my lord. If I am well protected, my lord, I will be able to show them, my lord.
No, even before the court, you can just show some element of the cattle being present, because this cattle was not found.
Kettles belongs to my lord, this Syamal Viswas. I have transported them. I have the,
No. I tend to forget because since I'm not taking up bail matters now, I am forgetting the case diary. But what I understand is that this cattle was not procured by one source. It maybe have been bought by someone, but the owner of the cattle are different. They are not the same person. So therefore, you have not been able to show that the cattle, supposing you are accused of transporting 10 cattle, the ownership of 10 cattle has not been able to be demonstrated by you. You are saying that this Biswas bought it.
Yes.
But the Biswas, he does not have the what you call permit to have those number of cows. So therefore,
Well,
there is a mismatch.
But the kettles were bought under the permits of Biswas. Permits were issued to Biswas.
Show me that I have forgotten. name.
One thing is that total 49 of cows found mismatch. One of the co-accused stated that he managed Munna Soikia, he managed everything in the Sri Rampur gate. He managed, and it was earlier rejected on 7th of February. Thereafter only I found the statement of one veterinary officer which is dated 10th of April. As per the officer, total 140 numbers of cow intimated to the officer, and they have the record of about 140 numbers of cows, and 49 later on distributed. The cows were brought outside by Assam, transported by Munna Soikia. Later on, they distributed to local villagers without informing us. So it is duty that veterinary officer they have to check, and then only so 140 numbers of they have record, but 49 cows without any record, and they have not been informed. And subsequently, it was not took to his that farm, the distributed among villagers, so that no one can search. That is the fact.
Show me that case.
That last
means-
I have played.
It means that I have forgotten.
One co-accused statement I have flagged and this veterinary officer.
But the man who had transported the cows are given bail.
Yes, yes. Lord. Yes, madam. The other two persons, this Syamal Biswas, he was granted regular bail, and this Habibur Rahman, he was given anticipatory bail by this honorable court. I have annexed the orders. As per the statement of the co-accused, he has managed everything. That co-accused I have flag mark, S mark has been given. Side.
This case diary should have been returned back. Once you are holding the case diary, that is why I directed that original case diary be sent back.
My lord, yes, it was intimated, but they have not taken back from Baksa, my lord. It's fixed again on 10/5.
Yeah, giving an interim bail to the petitioner, others have been enlarged. Let him produce the documents before the IO.
Samal Biswas was, my lord, after 35 days of custody.
So whatever we got, out of 3, 2 have been given bail. Mr. UJ Saikia, counsel for the petitioner, and Mr. KK Parashar, APP of the state. Next, the petitioner, who's apprehending arrest in connection with Govardhan PS case number so page 1. For here is bail. So the previous bail application of the petitioner was petitioner in AB 3852 of 2022 was rejected by order dated 7/2/2023. Next paragraph. The APP has opposed, has produced the case diary and has opposed the prayer for bail on the ground that no new ground has been made out to release the petitioner on PRS bail. Next one. Where is the FIR?
FIR page 9, my lord.
Next for the suit case has been registered pursuant to a complaint dated 21/12/2022 by the Inspector of Police from a Directorate of Vigilance and Anti-Corruption before the officer in charge of Govardhana PS, alleging illegal transportation of cattle and that there's been a mismatch of the quantity of livestock imported into the state of Assam from outside the state and cattle actually found on inspection. The IO suspects that the petitioner, along with others, had entered into a criminal conspiracy and by providing wrong information, has violated the provisions of Assam Cattle Preservation Rules of 2022. The first make it Act 2021 and rules came thereunder. It is also alleged that the transport permits were fraudulently obtained and that some of the cattle was also transported on the strength of cattle permits obtained in the name of other persons. By referring to the case diary, the Learned APP has submitted that out of 149 cattle,
So tell 140, matlab, 49 is matlab mismatch, matlab.
oh, okay, there's a mismatch of 49 cattle. Next paragraph. Taking note of the submissions made by the counsel to the petitioner that the petitioner would is granted PRS bill would cooperate with the investigation by producing all the necessary documents before the IO. Notwithstanding the rejection of the previous bail application, the court is inclined to grant interim PRS bail to the petitioner, namely so and so. At usual conditions, 50,000 with one surety of like amount. The petition shall appear with all the relevant documents before the IO within 10 days from today, failing which the interim bail would lapse on the 11th day. Next, for the IO shall send back the case diary and shall require the production of a status report of investigation from the IO instead of calling for the case diary. The production of the case diary is dispensed with because the FIR was registered on 21/12/2022. And therefore, reproduction of the case diary would cause further delay in the conclusion of an investigation. List on,
June.
give a date. Fix it in
5th of June, my lord.
5/6/2023. Case diary is returned.
Much of it. With up to date schedule, my lord.
No. Status report
Only
investigation.
status,
Otherwise, you will never give a, what you
My
call, that's why I've written in my order.
my lord.
You will not complete the investigation or not give charge sheet. That will not permit.
Only status.
36. My lord, this contempt was filed initially, my lord, in the earlier director Sanjeev Kumar Bhuiya, my lord, that my lord, he DCR, my lord. Thereafter, my lord, Dr. Vijay Chaudhary was also implemented, but she transferred, my lord. Now, my lord, I filed one implement petition, but my lord, which is not in the record. Today I inquire, my lord, they are, my lord, today find out and they are, my lord.
Okay.
Giving-
Mr. S. Chauhan, learned counsel for the petitioner submits that he has filed another implementing application, which is not on record. You filed it when?
My lord, file on 2/11/22.
2/11/22.
Filing number also there, my lord, 13163.
Under serial number, filing number
13163/22.
So the registry shall tag this matter along with the said interlocutory application. And this is preferably within a week.
My-
Lordship, for item number 31, Lordship, in the cause list, wrong name has been mentioned, Lordship.
Item,
That may be corrected, Lordship.
item,
31, Lordship. For which I am awaiting, Lordship. It should have been Barbhuya, not Bhujar Borua, Lordship.
31, okay. Okay, Mr. B. Chakravarti, and counsel for the petitioner submits that the counsel for respondent number 7
7 and 8.
and 8 is Mr.
AM Barbhuya.
A.M. Bormia and not the, and not
A.M.
Mr.
Bhujar
A.M.
Barua.
Bhujar Barua, which is wrongly mentioned in the cause list. Full stop. Next para, accordingly, the registry shall list this matter next week by referring the name of Mr. A.M. Bormia as counsel for respondent number 7 and 8 by listing the matter next. And who's for 9?
9 has, 9, Lordship, either UK Nair or HK Das will appear because district level service authority. Lordship.
Okay. In the meanwhile, the learned counsel for the petitioner shall serve a copy of the this writ petition to the The assisting counsel for Mr. U. K. Nair, senior counsel and standing counsel of this court. The proof of such service shall be filed with the registry prior to the next date of listing. Next paragraph. The registry shall also reflect the name of Mr. U. K. Nair, senior counsel and standing counsel for this court, as counsel for respondent number 9 by listing the matter next. What about 5?
But let them appear if necessary, I will take the step.
Next paragraph. Also say at this AM bug here. Say that the learned counsel to the petitioner also submits that as learned counsel has entered appearance for respondent numbers 6 and 7.
7 and 8, 7,
No. 6 and 7.
6 and 7.
6 and 7.
It may not be necessary because the president will be representing the school management committee.
In every likelihood, the said counsel will also appear for respondent number 5. And therefore, he prays for deferring the issuance of notice on respondent number 5 till the next date of the plea. It is considered and allowed. Next paragraph, this one answer.
22/5. Obliged.
I'll have to rise, there's a meeting now. Other matters I will not be able to take up. Yes, Mr. Siddhar.
I was waiting for item 55 of part 2, my lord. My lord,
Oh, I'll not be able to take up because I have
tomorrow will be done, my lord.
tried to take up. Just inform the other side
My lord.
in part 2 matters.
আপোনাৰ লিষ্টখন আমি কৰিছে নেকি আমি কেটা কৰা ঠিক আছে হ'ব
এলিমেন্টারি আছে তো এটা কোনালো যাও খালি রাকেশ বল নাকি ও কোর্স হ্যাঁ হ্যাঁ মোর গাড়ি নাই নো মোর নিলে বাপা নেই বলা না না 17 আছে 17 দেরি
ও একই ও গেল নাকি তো প্রায় এই